Welcome to a Legalbytes presentation of the Karen Reed murder trial. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel we make sense of the law one bite at a time. If you want more on the background of the Karen Reed case, check out our video on it linked in the description below. But otherwise, you be the jury. Did Karen Reed murder her Boston PD boyfriend John O'Keefe, or is she being framed by local police who Reed says are actually responsible for O'Keefe's death? Tell us what you think. But in the process, the one rule is don't be a dingus. Remember, everyone comes from their own perspective and opinion, and everyone comes to conclusions at their own pace. Agree or disagree, but always respectfully. Okay, let's get into it. All right, you guys, welcome back. Welcome back. Happy Thursday. Good morning, good afternoon, good evening, wherever you are coming in from. I hope that you are having a good one. Let me see here. This is not... Here we go. Oh, you know what? My sound. What is up with my sound here? Hang on. Aha. The culprit. That should be better. Okay. Now we're using the mic. Let me know what you guys think. Let me know. Should be better. Okay. Good. Good. We have Holmes wanting to steal some food that I have here, obviously, as always. We've got Mavi in the back. And Indy is probably hanging out with Mr. Bites at the moment. Okay, a lot better. So the judge just had a sidebar with the parties, and she is currently ruling on the motion that we heard, the motion to exclude, of course, that was the subject of the voir dire on Tuesday. That was day 27. We watched that. We got to see a little bit from the proposed experts by the defense, 3 experts who were awesome. And I really hope that all of them come in, even if it's just to a certain extent. I really want to hear them and their take on particular answers for particular questions that everybody still has, because we have those questions. Undoubtedly, the jury has those questions as well. So I'm really hoping that we get to hear from them. We will be watching, what her decision is, because it looked like she was about to get into it when I decided to pause and get started with the video. And before we do that, Lally Tally, let's do that really quickly, because I know folks are going to ask if I don't. Okay, so going into day 28, which is today. So the total going into day 27 was 1904. Day 27, the voir dire, we even got a couple what if any's, if you can believe it. Couple what if any's. So we actually made a mark on that. We're now at 1906. Will we get to 2000 today with the medical examiners? Because we still have the rest of Trooper Nicholas Guarino, his testimony. And I've heard some things about a voicemail that supposedly is very damning or damaging to Karen Reed. So we probably will be hearing that today, probably through Trooper Guarino. He was the one that we saw those text messages through. So we'll see him. And then we've got apparently 2 medical examiners left for the prosecution, and then they should be resting their case in chief. So we'll see. I have a feeling we will be able to surpass 2000 what if any's today. All right. Okay. So that is that. And anything else? I think that should be about it. No, Holmes, this is not for you. Okay. All right. Let's get moving. I've already got some questions that are saved in the chat. So if you add a Q, if you tag me, that's actually the best way for me to see it, or a big red question mark. Those are like visibly, they catch the eye for me. So if you guys have any questions along the way, I will pause. I will answer some questions as we proceed. Otherwise, we're going to pause for commentary, things like that. And we'll get caught up during recesses. So no worries that we're starting a little bit behind as always. Okay. I think that's about everything, right? We're good. Yes. Okay. We've got the Indy cam up here too, but Indy's not here at the moment. So, all right, let's do this, shall we?
So moving on to the voir dire motion the other day, or voir dire hearing in response to the Commonwealth's renewed motion for reciprocal discovery and motion to exclude defendant's expert, Dr. Marie Russell. So the Commonwealth was alleging violations of Rule 14's reciprocal discovery requirement, and the Commonwealth asked for exclusion of Dr. Russell. I did find and do find that there was a violation of the reciprocal discovery
I disagree.
obligations of the defendants. I was looking for a remedy. You called it a sanction, Mr. Jackson, but I called it a remedy. And I did tell counsel, as you know, at sidebar a couple of times, at least last week, that I did not want to exclude the testimony if I did not have to. So we had the voir dire, and I'm satisfied that the voir dire provided the Commonwealth the information that the defense should have provided the Commonwealth. So I am going to allow Dr. Russell to testify,
Yay.
but her testimony is very limited, and I think you even sort of acknowledged it the other day, Mr. Jackson. So she'll be allowed only to opine whether or not the marks on John O'Keefe's arm were the result of an animal attack.
Okay, so this is great. Okay, so remember, if you guys watched with us on day 27, let me come in right here. So if you guys watched with us on day 27, I said that with regard to, and I think I also said this in the recap. I said that the remedy, talking about the remedy here with the discovery violation, you know, when there is a discovery violation and the judge has to decide on a remedy, the whole idea is to even the playing field. And so here for her, the problem was that the prosecution really had limited ability to get information on this witness so that they could cross-examine her. And so for her, the remedy that I identified on day 27 was the ability for the prosecution to ask basically anything that they wanted of this witness on voir dire. So that was one, and I wasn't sure if that was going to be enough of a remedy in her her overall, like, you know, if there was going to be anything else that she wanted to add to that as far as like what she considered to be an appropriate remedy. I didn't think that anything beyond that would be appropriate. So here, I'm glad that she's determined that that's enough. I disagree that there actually was even a violation in the first place, because in order for there to be a discovery violation, the party or the attorneys involved have to have done something wrong. And it was very clear to me anyway that the attorneys here didn't even know that she existed. She's the one that reached out to them. That's out of the control of the attorneys. That's out of their hands. And so, you know, but I think that I don't know. She made that decision a little bit hastily, and that was the basis for why she allowed the entire voir dire. Anyway, what have you? It's fine. I at the end of the day, it's not a huge issue to me that she allowed this like extended kind of voir dire. I think that some of the questions that she was like kind of putting Dr. Russell through were a little silly, like asking about, you know, the degree of certainty that she had for her opinion. I mean, come on. Do we really want to ask Trooper Paul the degree of certainty that he had for his opinion? I don't think that was that would have resulted in a very good answer from Trooper Paul, to be honest with you. So, okay. Anyhow, well, that's a good decision. Now, she did just say, I did see here, there was a question about this. Janet G wanted to go back 5 seconds because she was talking about what she can testify about and what she can't. She said that she can testify on the about the marks on John's body, whether or like what she thinks is the origin, whether those are bite marks, but she can't testify to, she's going to limit that so that she can't testify to like whether or not she thinks that she's been in an auto accident or whether or not she thinks that John had been hit by a car or not. So that is that. And let's see. All right, we'll continue on. We'll get some more questions. I know folks have a lot of questions here. Also, Carmen Brown, thanks so much for the super chat. Can't wait for the Lally ride to be over. Firework. I agree. I'm very much looking forward to the defense's case in chief, and we'll see what. I mean, we got a little bit of a taste, I think, from the voir dire as to what the the cross-examination style might look like from Lally, we'll see. We'll see. Maybe he's a better cross-examiner than he is a direct examiner. Okay, let's continue on with this, and we'll see what else she has to say.
And that she is a medical doctor. She's an experienced ER doctor, albeit, several years ago since she's worked. She's an experienced ER. I find that she is a medical doctor. She's an experienced ER doctor, albeit, several years ago since she's worked in that capacity, but that she does have specialized knowledge in that field that may assist the jury in this regard. But she can't testify as an expert on police activity. There'll be none of that. And she will not be able to testify as to what the injuries are inconsistent with. She cannot testify that they're inconsistent with having been struck by a vehicle, road rash, scratches from broken glass or taillight matter, or anything else. So that's beyond the scope of what she.
I think that's lame. I think that she, if she wanted to limit her opinion to this specific injury here, as opposed to all of the other injuries, I guess I would be okay with that. But if she can testify that she thinks that this is from a dog, the logic follows that she also thinks that it's not something else. So that doesn't make sense to me. If for her to be able to say, yeah, I don't think that that's from a taillight shattering. Yeah, I don't think that that's road rash. That sounds like that makes sense for her to be able to say that. So that I don't agree with Judge Bev on that particular part. But to be fair, during the voir dire, Alan Jackson did say that they basically kind of conceded that point somewhat, that they said hey, look, we're going to, we have another forensic pathologist who's going to be testifying anyway. We're good. So whatever. That's fine. I'm sure it's not a big issue for the defense team then. So we can kind of, I guess, let that go. Even though I disagree.
Can testify. The second part of the Commonwealth's motion, Commonwealth argued that they were not provided reciprocal discovery regarding the biomechanical engineers and others, but specifically ARCCA, Dr. Wolf, and Dr. Rentschler. And I do find, though I understand why the defense didn't respond, but it is a violation of Rule 14. So we had this voir dire. The Commonwealth was looking to see what each person did, their independent opinion, what their testimony would be, and whether they were qualified to render the opinions that they qualified. So from what I heard the other day, Dr. Wolf can testify to what his involvement. Dr. Rentschler, though, I have some concerns. It's clear to me that in Massachusetts, biomechanical engineers are not qualified to testify as to medical causation of an injury. Only an MD can do that. So I'm going to reserve ruling on the rest of his testimony. There are certain things he can testify, and I'll hear you again before he testifies next week. Let's just proceed with the trial today. So, okay, so those are my rulings. Are they clear, Mr. Jackson?
Yes, sir.
Are they clear, Mr. Lally?
Yes, Your Honor.
Okay.
All right.
All right, so are they ready to come in? Thank you.
Okay. So before we get started with more testimony, well, we're going to, first of all, fast forward through this part.
All play come to you.
Okay.
Give the attendance, you shall be heard.
And then we're gonna get caught up on questions before we actually get started on this.
All right. Good morning again, counsel and Ms. Reed. Good morning, jurors. So we appreciate that you were patient, that we got a lot of work done this morning before you came out. It's cool in here now, as long as you're away from the sun from the windows. It should be fine. The county has done a really terrific job of making sure that they got this building nice and cool for us today. So I appreciate what the county's done as well. I do have to ask you those 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left on Tuesday?
Yes.
Everyone said yes, nodded affirmatively. Were you also able to follow my instructions and refrain from doing any independent research or investigation into this case?
Yes.
Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here on Tuesday? Everyone said no or should.
Great.
All
Okay.
right. Thank you very much. So may we call the witness, please? Trooper Guarino, please.
Okay. So we're going to continue with Trooper Guarino's testimony, but first let's get some questions here. And of course, as always, we will get caught up on all of this. Okay, let's do it this way. All right. Mr. Baker, will the judge make a ruling on the experts from Tuesday? Well, we just saw that, so we can asked and answered. River Duck 77 question: did you catch Judge C putting words in Dr. Russell's mouth about how certain she was? Doctor said high medical certainty when judge said reasonable. The judge used that to claim doctor was uncertain. Yeah, that was weird. It was weird, especially because she never asked well, I mean, we never quite heard, I guess I should say, whether or not there was any degree of certainty by the illuminative Trooper Paul. Okay, JB question: can the defense work with Dr. Bennett to ensure her testimony runs more? Oh, you mean Dr. Russell, to ensure her testimony runs more smoothly in front of the jury? She knew her stuff, just stumbled a bit. Yes, I imagine that they will be working with her a bit to sort of work out the kinks and sort of what they're gonna go through. This sounds like this was like one of the first times that they even had a conversation with her, other than that one over the phone back in mid-May. So she hasn't even had time, or she hasn't put together a report for them. So I would imagine that there's going to be some prep time between them, just to sit down, discuss, and go over kind of sort of basic prep work for an expert witness. And same thing with the other two experts as well. Sue B question: wouldn't a vet be better at explaining dog bites? Not necessarily, no, because when you go to a vet, you're bringing an animal to a vet, not necessarily a human being to a vet. When a human is bit by a dog, they don't go to a vet, they go to a doctor. They go to an ER doctor more often than not. So I think that the person that they got is better than trying to get some kind of a vet or something. Melissa Garcia: do you think this judge didn't delay the case because she wants to be famous? I have no idea. I don't know. I can't say one way or another what's going on in Judge Bev's head. Oh my gosh, we've got so many more questions popping up. Okay, I'll try to get to all of these, but we do definitely want to get to the testimony as well. Okay. Travis James: will Jennifer Love Hewitt be testifying today? I don't know. Something tells me probably not. Okay, let's see here. Okay, I think I've got everything here. All right. L. Mahoney. Oh, sorry. No, I did not answer this one. Jimbo and Nick talked and are back on good terms. Legalbytes question: are you married? If not, will you marry me? I promise I'm not a weirdo. Well, I am married and in the process of building a family with Mr. Bites. So I apologize. I'm very complimented, but no, I'm very much taken. L. Mahaney question: does the defense get a chance to prep Dr. Russell? Yes, they will. They will for sure. LK Ryden: Legalbytes, I think she stuck to the violation because she thinks Jackson is lying. She was weirdly suspicious that both defense were, but more than anything, Dr. Russell during the last hearing. So strange. Yeah, I thought that was strange too, because she was under penalty of perjury. Yeah, Dr. Russell was. So Rubber Duck 77. Legalbytes question: if Lally asked she considered anything else, does that open the door? Yes. And that was also a point by Link Journey. This could put Lally in the position to open the door on cross. Absolutely. If he does ask about like, well, this couldn't be something else, or, this something like that, knowing that she can't testify to that, she's allowed to give an opinion, and then that can be redirected. So that is an example, a prime example of opening the door to testimony that is otherwise not allowed. Billy Arnold 33 question: what is your kitty sleeping in? My cat would love one of those. I'll show really quick. Hey. It's basically just a plastic bin with a scarf on it. I got it on like Amazon or something. So there we go. Wait, let's see. Yeah, it's cute. I love it. Okay, Larry Huffin question: what do you think is Judge Cannone's reason for only letting her opine only on the dog bite? She's got enough experience to opine on anything else in this case, yet the judge says no. I mean, The purpose that she said is because her real expertise here, the main reason for her to testify is about bite wounds. It's very clear that she is like the prime person in the United States, basically, to be able to talk about that. I think that it maybe if they had gone during voir dire into more of her extensive knowledge, and experience with her ER work and with the county coroner, perhaps the LA County coroner, on injuries related to auto accidents, pedestrian accidents, things like that. Maybe we could have seen her testify more to that kind of thing, but I don't know, for whatever reason she was just very, very skeptical of her expertise on that, which is just insane. It just so laughable considering the experts that we've seen on the other side. Sarkadoodle Legalbytes, how is it a violation for the reconstruction witnesses if the FBI handed both parties the data? Even if the FBI did it, do defense still have to hand it over to double work? I mean, the defense would still have to hand over what they have in case there's anything different. So there is that. But I think that the discovery violation here that the judge talked about was not so much about those other two, the accident reconstruction experts. It was mostly about Dr. Russell, or I think exclusively about Dr. Russell. So yeah. I'm not entirely sure. I mean, I know why she said that there was a discovery violation. I personally disagree. Janet G. Legalbytes, off topic of this case. Alec Baldwin trial will be coming up soon. It's a busy trial summer. Will you be covering gavel to gavel? I think you said you wanted to, but with baby bites, yes. So I will still be in a good enough state to be able to cover that one gavel to gavel. If it's as long as the Armorer trial, which is the companion case to that one, the Hannah Gutierrez Reed trial, that one was about 2 weeks long. So that should be fine here. It'll be the time zone will be a little bit different because it's out of New Mexico as opposed to the East Coast, but yeah, we'll work through it. But yes, 100% plan to cover that one gavel to gavel and with recaps. I didn't do that with the Armorer trial, but I will be doing that with the Baldwin case. So definitely stick around for that too. Buttercup 203. Oh wait, yes, all three are allowed, just limited. Yes, that is the case. Nico Kiski, question, what do you think about AJ's body language? I noted he seems to be restrained when talking to the judge or defense experts, but in tough crosses, he gestures and moves a lot more. Yeah, I think he's a very passionate attorney, I think. So that is something that I have definitely noticed about him is he's when he's on cross and he really feels like he can let it rip, he lets it rip, including with his body language. Juliet Satita, 639, question, why wouldn't these experts be allowed when they were hired by the feds? Well, keep in mind, the court is not necessarily going to just trust the fact that the federal court is, allowed them to testify on certain things. This is a different jurisdiction. They're going to do their own analysis, and that's entirely proper and entirely fair for the judge to say, okay, that's fine. Federal court is federal court, but I'm a judge in this court. They have no bearing here. So she doesn't have to follow the same decision as what some federal court, even if it's also a federal court in Massachusetts, she's not required to follow the decisions that they did. And that also, hey, feds can get things wrong too. So the fact that the feds are investigating, the fact that these were experts hired by the feds, that really doesn't necessarily mean that they are in fact good expert witnesses. In this case, they absolutely are great expert witnesses, in my opinion. But you can't just take that at face value. You've got to do your own analysis as well. Also, sorry, I should have gotten this earlier. Chad, thank you so much for becoming a YouTube member. Welcome to Bite Club. Very happy to have you here. On Saturday at 10 a.m. East Coast time, we will be having our members only live stream. We also are going to be coming out with another video today, tomorrow, at some point, that is totally unrelated to the Karen Reed trial. With a little bit of a break, I managed to put together something. So we'll be getting something out. And members of Bite Club, whether it is through YouTube memberships or supporters on Patreon, will have some early access to that video before it gets put out to the general public. That's one of the benefits of becoming a member of Bite Club, which is awesome. So thank you so much for joining Bite Club, for supporting the channel. It is super helpful because, it takes a lot of resources to put on, especially like a full-blown trial, but even just throughout the year when there isn't a high profile trial happening, all kinds of content that we're going to be putting out. It takes a lot between the research and and script writing and editing and all that kind of stuff. So thank you so much. Very, very kind of you. And also MZ, thank you so much for gifting 5 Legalbytes memberships. So kind and generous of you. Also supporting Bite Club. I love to see it. So let's see here. Juliet Satita 639. Wheaton is what? Sophie 1518. Joey G17 and Kelly E. Rayborn. You have all been gifted memberships by MZ. So welcome or welcome back to Bike Club. So happy to have you all here. MZ, thank you so much once again. Also, okay, let's get some more questions and then we've got to get on with the testimony. LK Ryden, something about the judge's behavior around Dr. Russell makes me uncomfortable. Am I reading into it? Don't like saying it, but I get a woman competition feel. Don't know why. Sometimes it happens. She definitely seemed to be more skeptical of Dr. Russell for some reason. Maybe it's because she's less familiar with her as opposed to the other 2 expert witnesses, knowing that they had already testified in a grand jury hearing. Maybe that's the reason for it. But I mean, she definitely did seem a bit more skeptical of her rather than the others. Buttercup 203 question: if the 2 ARCA guys testified in grand jury, they came back with an indictment. So are they defense-friendly testimony? They seem to be defense friendly. Yeah. Based on what I know of what came out of the hearing, the conclusions that they had are definitely consistent with the defense theory for sure. Wheaton is what? Question: would you mind putting guilty on a lesser charge of involuntary manslaughter in the polls? I'm curious as to what this chat thinks. We can definitely do that at some point. Thank you for that. Fairy Moon 71 question: do bites before or after death? So this witness has also had experience as an ER doctor, Dr. Russell, as an ER doctor and as a consultant with the LA County Coroner's Office. So she's done autopsy analyses and stuff like that in the past. So I think that she will be able to distinguish between the 2 as well from based on her background anyway. We'll see how she testifies. Aiden and Legalbytes, maybe after seeing quality of some CW experts, judge wants to make sure only real experts testify from now on. Yeah, but that's the problem though, is if you're only having the higher standard for one side, that's not the best. But I see what you're talking about. Stephen Horton, Legalbytes, have court cases made choosing baby names harder? Actually, no, not really, especially because, we've got family traditions and all that kind of stuff that we're looking at and, cultural stuff that isn't less common in the United States. So I guess for us, it's not as hard. It's not like, when someone is a teacher, when one of the parents is a teacher, I feel like that makes things so hard because you have all kinds of ways that you rule out names when you've got kids rolling in every single year. Jerry Roth, Legalbytes, how did Trooper Paul get through as an expert, as it seems like he would fail both tests you mentioned in your recap video? I don't know. I can't. I don't know. It's yeah. I don't know, to be honest with you. Based on his personal qualifications, I can't answer that. Baz 80s question: are you expecting ME to lean defensive prosecution? The medical examiners who are testifying today, tomorrow, I expect those to be prosecution friendly. And Larry Huffin, one more question: how are you and Baby Bites doing? Sending my love to you both. Thank you so much. We're doing well. Okay, let's get back to the testimony. Let's get to it. All right. Enough time, right? Enough lollygagging. Okay.
Step up.
To the court
Okay.
and the jury, and the matter now pending shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
Thank you.
Good morning, Trooper.
Morning, everyone.
Whenever you're ready, Mr. Lally.
Thank you. Good morning, sir.
Morning.
Taking you back to the other day, I have been showing you, so you had testified about some extraction reports that you had conducted from the various forensic extractions that you had done pertaining to both the defendant's phone and Mr. O'Keefe's phone, correct?
Yes, sir.
And Your Honor, may I approach?
Yes.
Okay, so we're going to get some more from extractions from their phones.
Brooke showing you a document, asking to review that with open finish.
Okay.
TJM, thank you so much for the super chat. Baby Bite Diaper Fund contribution. Thank you. Very sweet.
Okay.
You recognize that, sir?
Yes, it's,
What do you recognize that to be?
sorry, Karen Reed's phone call logs.
And that's specifically from January 28th and January 29th, is that correct?
Yes, it starts the 28th at 12:33 to, I'm sorry, the 29th at 12:33 to 3:19 p.m. on the 29th.
We're gonna
And
put
just
the
for ease of
1.25.
reference, does it sort of go in descending order as far as the earlier calls are on the last page and then the more recent calls are on the first page?
Yes, that's correct.
May I approach, Ron?
Yes.
May we approach, please?
Okay. They are going to do a sidebar and we will fast forward. But yes, we are at 1.25x speed because it's a Lally Direct. Why not? And we're behind.
Yes,
What do you recognize that to be?
this is Karen Reed and Carrie Roberts' call log.
And that's an extraction report that you created from the defendant's phone, is that correct?
Keep your voice up, Mr.
Yes, sir.
Yes. Sorry, yes.
May I approach again, Your Honor?
Yes.
I'm going to seek to introduce in the minutes and executive.
Okay.
No objection.
It's 6:34.
May I approach again, Your Honor?
Yes.
Showing you another document, sir, to recognize that.
Yes,
What do you recognize that to be?
this is the chats from John O'Keefe and Chris Albert.
And again, that's an extraction report that you created from Mr. O'Keefe's phone, is that correct?
Yes, it is.
May I approach again, Your Honor?
Yes.
I'm going to seek to introduce in the minutes and executive. No objection.
Mr. Lally, you really do need to keep your voice up. It's 6:35.
And may I approach, oh, I'm sorry. My apologies. May I approach again, Your Honor?
Yes.
Showing you another document, sir. I ask you to look at that. Look up when you're finished.
Yes,
Do you recognize that, sir?
yes, this is Karen Reed's, the full chat report of everyone from the 29th on. So,
May I approach, Your Honor?
Yes.
I'm going to seek to introduce in the minutes and executive. We have no objection.
It's 6:36.
Okay. So he's gonna
May I
be
have the last-
introducing all of these different exhibits and then we're going to probably.
May I approach the witness, Your Honor?
Yes.
Okay, we're trying to view what's now been marked as Exhibit 636. Your Honor, with the court's permission, may I call this portion of this to the jury?
Yes.
And sir, I'm going to direct your attention to the exhibit before you that's now been marked as Exhibit 636. And Ms. Steelman, if I could, I'm sorry, Guarino and Ms. Steelman, if I could direct your attention to page 3.
Oh, me. No.
And do you have that before you, sir?
yes, I do.
And on page 3, who was that a conversation with?
Laura Sullivan?
And that conversation essentially continues from page 3 to page 6. Is that correct?
Yes, it does.
And so I'm going to ask you, similar to what I asked you the other day, if you could read from that conversation in its entirety, indicating who's speaking, content of what's being said, and the date and time associated with that message.
Yes. First message from Laura Sullivan at 12:45 p.m. on January 29th, 2022. Karen, it's Laura. Please call me. Karen says, hi, Laura, at 1:07 p.m. Karen then says, John passed away, 1:07 p.m. Laura, Karen, I'm shaking. I'm so sorry. At 1:07, Karen says, we found him outside in the snow at 5 a.m., 1:07 p.m. Laura, I can't stop crying, 1:07 p.m. again. Karen, thank you, 1:07. And Laura finally says, why was he out there, 1:07 p.m. Oh, sorry. Karen replies, he left the party we were at. I don't know what time. I didn't even go in. I went to bed. That's at 1:08 p.m. Laura says, oh my God, 1:08. Karen, my heart breaks for, my heart breaks for everyone at 1:09 p.m.
Thank you. So with those text messages, Ms. Sullivan, in the afternoon of the 29th, she indicates to Ms. Sullivan that they located Mr. O'Keefe around 5 a.m. Is that correct?
Yes, it is.
Now, sir, if I could direct your attention to page 28 through 29 of those messages in the exhibit before you. Page 28 to 29, who's that conversation with?
This is Karen Reed and John O'Keefe.
These are conversations from the early. These conversations on page 28 through 29 of this exhibit occur in the early morning hours of January 29th, correct?
Yes, that's correct.
And if you could, sir, again, please read as far as who's speaking, what they're saying, and what date and time these are being sent.
Yes. So, Karen Reed to John O'Keefe at 12:55 a.m. on the 29th. I'm going home. Followed by, see you later. At 1:02 a.m., she texts John again saying, your kids are cucking alone.
Have you seen these?
And at 1:04 a.m., she says, I'm back in Mansfield. The kids are home alone.
Yeah, we saw these earlier.
Thank you. May I approach just to retreat?
Yes.
May I have a moment, Chairman?
Yes.
May I approach?
Yes.
Okay, let's.
And Mr. Officer, we can put the light. You recognize each of those documents, sir?
Yes, one is Karen Reed call log report. Just want to confirm which one this is. Yeah. For John O'Keefe, and then John O'Keefe's full call log report on the, looks like the 29th.
Now, sir, if I could direct your attention to the defendant, Ms. Reed's call log reports, and specifically, if I could draw your attention to what's been, they're enumerated as far as certain box numbers, correct? 1 through whatever it goes on the last page.
Yes.
If I could direct your attention to boxes 113 and 114.
Okay.
See those entries, sir?
Yes.
Now, as far as the time related to box 113 and 114, what are the timestamps associated with that?
129/2022 at 12:36 a.m. 41 seconds, and then another one at 12:36 and 10 seconds a.m. on the 29th.
And is there any indication within that report as far as whether or not those calls are answered, those calls are missed, those calls are rejected? What's listed?
It says answered.
And we'll get to this a little bit more in a moment, but with regard to that 12:36 time, from your review of both the defendant's phone and Mr. O'Keefe's phone, is there a voicemail that the defendant left Mr. O'Keefe at that time frame?
There was a voicemail at 12:37 a.m. These ones here, it looks like they're 3 seconds and 5 seconds long.
And they're listed as answered, is that correct?
That is correct.
Now, sir, if I could turn your attention over to Mr. O'Keefe's call report. And specifically, I'm going to ask you to direct your attention to what's been labeled as box number 134 and then 134 with the 1 in parentheses following.
Okay.
And do you see those entries, sir?
Yes.
And what is the date and time associated with those entries in Mr. O'Keefe's records?
His records shows number 134 is 12:36, 9 seconds on the 29th, and then 134 with the 1 in the parentheses, 12:36 and 9 seconds as well. Call duration 0 seconds.
And as far as any indication on those calls, as far as whether they're answered, they're missed, they're rejected, or what are they listed as?
There's nothing. Also 133 is the same call, and that one says missed, and it's at the same timestamp of 12:36 and 9 seconds.
So the same call around the same time frame shows up in Mr. O'Keefe's report as missed and shows up in the defendant's report as answered, correct?
That is correct.
And that's around the time that the defendant is calling the victim repeatedly and leaving voicemails on Mr. O'Keefe's phone.
Yes, that's correct.
May I approach this to retrieve, Your Honor?
Yes.
So we're probably about to hear voicemail. And for the actual
Yes.
voicemail, I'll slow it down to regular speed so the people can hear it at normal speed.
Now, Trooper Guarino, you conducted an analysis of both the defendant's phone and Mr. O'Keefe's phone, correct?
That's correct.
And from your analysis of that phone, were you able to determine approximately how many calls occurred from the defendant's phone to Mr. O'Keefe's phone from the time period shortly after 12:30 a.m. To the time period shortly after 6 a.m.?
There was over 50. I think it's 53 or 55. But
And any of those calls from your review of those records indicate any sort of conversation as far as duration, as far as being labeled as answered, anything to that effect?
that Mr. O'Keefe actually picked up the phone and spoke to Ms. Reed?
Yes.
No.
Now, with regards to those phone calls from the defendant to Mr. O'Keefe, what, if anything, did you find from Mr. O'Keefe's phone in relation to voicemails left by the defendant?
There were should be 8 voicemails on Mr. O'Keefe's phone from the 29th till the phone was discovered. All from Ms. Reed, no one else.
May I approach, Your Honor?
Yes.
Eight voicemails is kind of a lot, but remember, she had apparently called him 18 times throughout the day.
Agree with this, sir?
I wonder how many of those were from earlier
Yes.
in the day.
What do you recognize that to be?
It's the John O'Keefe voicemails from Karen Reed on his phone.
From that period that we were just speaking about on January 29th?
Yes, that's correct.
May I approach, Your Honor?
Yes.
I'm going to introduce in the minutes the next exhibit. We have no objection.
Okay. It's 6:37.
Now, sir, from your review of the defendant's phone, before we get to those, from your review of the defendant's phone, what, if anything, were you able to observe or ascertain that the defendant's phone did at approximately 12:36 a.m.?
So by looking at the timeline in the phone, we were able to see that Ms. Reed's phone auto-connected to John O'Keefe's Wi-Fi at his house at 12:36 a.m. We know this because it's a password-protected access to the phone, so you would have to know the password to get into this Wi-Fi network.
And that would be the home in 1 Meadows Avenue, correct?
Yes, that's correct.
And, Your Honor, with the court's permission, if we could publish each of the 8 voicemails to the jury.
Okay. Are we going to hear which time each one is?
Yes, Your Honor.
So by 12:36 a.m., she was back at John O'Keefe's house. I know there have been some questions about the
And Trooper Guarino, again, similar to the other messages, just for point of reference, the earliest of the voicemails is the last in the list, and the most recent is at the top of the list. Is that correct?
Yes,
Now, as far as this first voicemail, what time did this occur?
12:37 a.m.
And with the court's permission, if I could play that for the jury.
Yes.
Okay, hang on. We're gonna get this to normal speed now.
Ms. Gilman, if you could have the second message.
Oi.
Sorry, Ms. Gilman, if you could pause right there, please. My apologies, Your Honor, I just wanted to.
Okay, so the sirens are in the voicemail, not in the
Before
courtroom.
Ms. Gilman presses play again, Trooper Guarino, what time is the second message?
12:42.
Ms. Gilman, if you could.
This sounds like a legitimate butt dial.
Now, Trooper Guarino, with reference to the third message, what time is that received?
12:59.
And again, when I say received by Mr. O'Keefe's phone, is that correct?
That's the timestamp of the voicemail in his phone. Yes.
And Ms. Gilman, if you could, with reference to that third message.
John, I'm down with your fucking kids. Nobody knows what the fuck you are, you fucking pervert.
Now, the fourth message, Trooper
Oh,
Guarino, what
yeah.
time was that received by Mr. O'Keefe's phone?
1:02 a.m.
Ms. Gilman, if you could, when you're ready.
That was it.
So can we just turn the air conditioner off for just a second, please? So you just played it?
Yeah, Your Honor, there was no content. It was just like a 1 second long message.
And Trooper Guarino, with regard to the fifth message, what time was that received by Mr. O'Keefe's phone?
37, 42, 59, 1:11 a.m. Excuse me.
And, Ms. Gilman, if you could.
Yes, 1 in the morning, I'm with your fucking niece and nephew. You fucking pervert! You're a fucking pervert!
In the 6th message, sir, what time was that received by Mr. O'Keefe's phone?
1:18 a.m.
Gilman, if you could.
John, I'm going home. I cannot babysit your niece. I need to go home. You are fucking using me right now. You're fucking another girl. He's sleeping next to me. You're a fucking loser. Fuck yourself.
The 7th message, sir, what time was that received by Mr. O'Keefe's phone?
5:23 a.m.
Okay. Here's a question. She says that he's, in that 6th message, she says you're effing another woman. You're an effing pervert. She mentioned in one of the earlier voicemails, you're a pervert. And that is like, it seems to me that these voicemails are because she thinks that he's cheating on her. What? Okay. Just, taking a step back here. What would be the reason? Like, what would be the prosecution's explanation for these voicemails? Are they saying that she's trying to cover up her tracks after hitting him? By saying that he had already cheated on her. She thought that he had already cheated on her. And so therefore she still was holding on to this whole Aruba thing. God, I can't get it right still. That the whole Aruba thing, that she was still holding on to that, okay, maybe, but like that was the reason why she hit him. And that she's still very angry with him. She clearly says you're with another woman right now. I don't know. I don't know. To me, it seems like she thinks that he's still alive, and she's actually raging at him because she thinks that that's what he's doing in that moment, and that's why he's not picking up. So, I don't know. Okay, let's continue with the voicemail number 7.
Gilman, if you could. The last and 8th message, sir, what time was that received by Mr. O'Keefe's phone?
6:08 a.m.
Ms. Gilman, if you could. Gilman, if you could pause there for 1 second, I'm sorry. With respect to this message received on Mr. O'Keefe's phone at 6:08 a.m., from your knowledge of the investigation, where was the defendant, who, if anyone, was with her or around her at the time of this message at 6:08 a.m.?
Jen McCabe, Carrie Roberts. During the message, you can hear someone on the phone with 911.
Thank you, sir. Ms. Gilman, if you could.
Yes, I need someone to make the 34 years old, getting out, and they can't have notice now. Yeah. Weird blanket. I don't see blanket terrible. Yes, I need
This message before. This is a butt dial. A legitimate butt dial.
I don't know either. You know, Carrie, you know, I'm you're right. I don't want that. I'm
Yeah, that rhythmic thing is like windshield wipers. I think that was explained before.
Thank you, Ms. Gilman.
Can we turn the air conditioning back on? Thank you very much.
Yeah, we heard that last one through Jen McCabe.
Now, Trooper Guarino, in addition to the 53 phone calls that you've testified about, the defendant made to Mr. O'Keefe from that time frame following 12:30 a.m. to approximately just past 6 a.m. Did you note any other calls to a contact listed within the defendant's phone as mom?
Yes.
And when were those calls placed?
I believe there's one at 1:10-ish in the morning. I forget the exact timestamp. There's also one at around 4:40 in the morning, and then at 4:42, right around 4 in the morning. Two of them, the first two weren't answered, and then the third phone call was answered.
Now, with respect to Ms. Reed's phone from that same time period, what, if any, phone calls did you observe to a contact listed in the defendant's phone as dad?
It's the same number. So when I looked at it in one report, it showed as dad, and then when I looked at it in Cellbrite, it came up as mom. So I don't know how it's attributing. Maybe she has it listed twice. I never looked at her actual phone. So this is what the extraction is showing me.
Now, sir, you testified the other day.
Hang on, we're gonna get it back to 1.25 now that we are through the voicemails. But okay, let me first say this about the voicemails. You know, yes, okay, she's screaming at him. She's saying, "I effing hate you." That sounds like something that one side, if they really wanted to prove that there was a killing in the heat of the moment, kind of a passion sort of killing, that would also be accompanied with statements like that. I think that that's what they're trying to say here with these voicemails. But in the context of the prior argument that they had and her conversation with Brian Higgins, where it sounds like she had already been like kind of pulling away from the relationship with John O'Keefe to a certain extent. And earlier in that day, you know, Karen is kind of saying like, you know, just basically like it sounds like you're basically out, and just admit it that you're basically out. All of that together, combined with the other circumstances of her life. She's got her own home. She's got her own career. She's got her own money. She's got a pretty decent life overall from what it seems on her own, aside from, of course, the medical issues that she's got. She's got Crohn's disease. She's got MS, which those are, you know, fairly significant things that could create, you know, feelings of abandonment or fears of abandonment, things like that. Those could cause someone to have those feelings. But I mean, other than that, aside from that, she's got her own resources. So it does seem strange to me that she would go down the path of choosing literal violence when she has, when it's becoming apparent perhaps to her that maybe the relationship is ending. It just, especially when in Aruba, there was no allegation whatsoever that she had ever used violence back in Aruba. So like there's no pattern here to show that when she gets angry, when she thinks that something big has happened in their relationship and she's convinced that he's cheating on her, that she does something violent. It doesn't necessarily need to be that way. But there doesn't seem to be excuse me. It doesn't seem to be that pattern. Excuse me. Okay. Let me get some super chats really quick here. And then we'll continue on with the testimony. We'll get some questions in a bit. Heather Miller, thanks so much for the super chat. I feel like if she was trying to cover her tracks, her messages would be more of, John, where are you? I'm so worried. I agree. I definitely agree. Megan Rose, someone should play these for the McAlberts to show them what a real butt dial is. I do agree. Thanks so much for that. TJM, thank you. Also, at this point, I hear what, if any, in my dang sleep. Agreed. Draco Amy, member for 12 months. Welcome to a year of membership. Taco, shine on, my friends. Lovely, lovely. Welcome to Taco Level. So happy to see it. And also thanks for being one of our wonderful, wonderful mods. Okay, let's continue with this testimony and we'll get some more questions in a bit.
That's upon your review of the defendant's extraction reports, we're not able to determine there were no listed GPS locations for the defendant's home.
Correct. Like routes or anything like that.
And that was because it was turned off in the phone. Is that correct?
That would lead me to believe, yes, that location services are turned off. So,
Objection. Move to
Yep, so no gas. What can you tell us about that?
well, if GPS coordinates and location services on, that's what would get us locations in the phone. So if they're not there, they could be turned off.
Objection. Move to strike.
We're all about it.
Now, with respect to Mr. O'Keefe's phone, what, if any, analysis with respect to GPS and or health data? Well, let me ask you this first. From your training experience and your casework with respect to forensic analysis of electronic devices, what is health data in a cell phone? How is that recorded, and what, if anything, can that tell you?
Okay. So in an iPhone, you can have health data. To use that health data, the phone, if you don't have an iWatch paired to it, is basically just a high-tech pedometer. It's just every time you move the phone, it's going to track steps, and that's if you have it turned on. If you have the iWatch on, it'll get beats per minute, and you get a much more robust health data from it.
Now, with respect to the health data and with respect to the GPS location for Mr. O'Keefe's phone, initially, what, if any, sort of analysis did you do with respect to that?
So we checked his native locations. At 12:19, the phone is, well, I should say this, at 12:12 in his location shows that he's at the Waterfall Bar. The next set of locations shows he's at Dedham Street by Cedar Crest, and then Waze is activated for 34 Fairview. So, and then it shows me his entire route to 34 Fairview.
And what is Waze, sir?
Waze is some of the Apple Maps. It is the GPS program that, punch in like a Garmin type thing.
If I could take you back just for a moment, just to the health data from the Cellbrite extraction that you did. Specifically, you looked at data from 12 a.m. to 1 a.m. on January 29, 2022. Is that correct?
Yes, that's correct.
And as far as the health data was concerned, there were some entries from 12:11 a.m. to 12:32 a.m. Is that correct?
Yes, that's correct.
And can you describe to the jury sort of what you observed and what, if any, significance those entries had to you as far as the health data was concerned?
Yeah, so the health data shows, like I said, the phone is basically a high-tech pedometer. If you're moving it around, it's going to think you're taking steps when you might not actually be walking. His health data showed while he's driving that he's traveling and taking steps.
So I need a foundation.
Guarino, over the course of this investigation and your analysis, you became aware of other witness statements, surveillance video, things of that nature as to Mr. O'Keefe's whereabouts from approximately 12 a.m. to at least 1 a.m. Is that correct?
Yes, that's correct.
And you're aware of around the time just past 6 a.m. When he was scheduled.
So let's get a question.
Oh, that's my objection.
He's testifying.
You're aware of the time being just past 6 a.m. that you already testified to as to when Mr. O'Keefe was discovered and 911 was called.
Yes, that's correct.
So, sir, with respect to, again, that time period starting at 12:11 a.m., what, if anything, did you observe with respect to the health data of Mr. O'Keefe as signified within the phone?
So it marks when he's taking steps, ascending, or should say, yeah, ascending stairs, and distance traveled.
And so from that period of 12:11 to 12:32, there were essentially 4 time periods that you delineated. Is that correct?
Yes, that's correct.
And do you remember the precise times and sort of distance traveled within those time frames?
I don't remember the precisely off the top of my head.
Your Honor, with the court's permission, may the trooper refer to his report just for those
Yes,
numbers?
we have it with you, Trooper?
Yes, Your Honor. Thank you. Okay.
And sir, if you could just list for the jury what you found.
Yes. So at 12:11 and 9 seconds in the morning to 12:21 and 5 seconds on the 29th, it shows that he's taking 170 steps, going 99.6 meters or 326 feet. At 12:21 and 10 seconds to 12:24 and 22 seconds, it shows 80 steps and 87.74 meters or 287 feet. At 12:21, 14 seconds to 12:24 and 37 seconds, it stated ascending, descending 3 floors. And then at 12:31:56 to 12:32:16 in the morning, 36 steps, 25.46 meters or 85 feet.
Now, sir, with respect to what's listed as steps, does that indicate, from based on your training experience and familiarity with this sort of health data, what, if anything, does that tell you as to whether or not the person with the phone is physically taking steps?
That's not the case.
What is the case?
Like I said, the phone has internal measures.
Go along.
The phone has internal measures in it. Like I said, it's basically a pedometer. So the movement of the phone, the distance traveled, it's going to register as steps. You don't have to physically be walking and moving the phone for it to register movement. Just waving around and then could potentially cause it to think you're walking and moving.
You mentioned that from your review of Mr. O'Keefe's phone, you indicated there was a Waze search for 34 Fairview Road. Is that correct?
Yes, that's correct.
And if you could just explain to the jury sort of what is Waze and what kind of information are you looking at there?
Waze is a GPS program. So you put your address you're looking to go to. It's going to tell you the fastest route, where the police are, etc.
And when that Waze search was conducted, is there a precise time pursuant to your review of Mr. O'Keefe's phone associated with that Waze search?
Yes, it was at 12:20 in the morning.
And so from all of those steps and everything that you, if Mr. O'Keefe is searching for 34 Fairview Road, inferably he's not at 34 Fairview Road. Is that correct?
That is correct.
Now, with respect to the location, can you describe to the jury, are you familiar with the term based on your training experience known as native locations?
Yes.
And can you explain to the jury what that is?
So native locations on an iPhone, the way it pulls GPS data, it uses satellite, Wi-Fi signal, Bluetooth, location services on apps. It takes all that data and uses it to get you the best location of where you are, unlike where you'd have like a handheld car-mounted Garmin GPS that's just using strictly satellite.
Now, from your review of that data, when that Waze search is conducted at approximately 12:20 a.m., where is Mr. O'Keefe physically located at that time?
The vehicle, or whatever they're in, is by 138 Dedham Street. They had already passed Cedar Crest Road.
And from review of that native location data, what time does the phone arrive in the area of 34 Fairview Road?
12:24 a.m.
Now, the next entry as far as the location data, when is that and where is it indicating that the phone is at that point?
That shows me it's there the entire night, right in between 32, 34 Fairview. So,
And 32, 34 Fairview, that sort of intersection of those two residences, if you know, where is that in relation to where Mr. O'Keefe was found just after 6 a.m. in the morning?
I was only going by the photos that Sergeant Good had taken and from the Canton PD cruiser cam, but that area would be within 3 feet, give or take, of the area where the GPS signals all plot for the rest of the night.
Now, Trooper Guarino, you testified the other day to a tool that you use called Axiom, is that correct?
Yes.
And with regard to the location data in the tool of Axiom, what, if anything, can you tell the jury as far as how that works and how accurate it is?
So, like Cellbrite, Axiom will also show the native locations in an iPhone. They're able to display the range of accuracy in meters and then also the speed of the phone in meters per second.
And were you able to ascertain from using the Axiom tool and the location data for Mr. O'Keefe's phone as far as its speed in meters per second at 12:25:36 a.m.?
I don't remember it off the top of my head.
Your Honor, with court's permission, may the trooper refer to his report for the numbers?
Go ahead.
It's 0.6 346 meters per second and a 16.75 meter lever of accuracy. So at about 54 feet measure of accuracy.
Now, sir, if you could, just based on your training experience and your use, familiarity with this Axiom tool, for the record, that's AXIOM, is that correct?
Yes, that is correct.
So as far as that degree of certainty or accuracy with regard to the measurement, can you speak a little bit about that and explain that to the jury, how that works and what that means?
Yeah. So, as I said, the iPhone tries to use multiple things to get you the best area of location where you're at. I can tell from personal experience that being at 34 Fairview, it's at the bottom, Fairview, where 34 is on Fairview. It's at the bottom of a hill, and it's also at the bottom of Cedar Crest, where they sort of intersect. That area there has many hills, so the GPS signal can weaken due to natural landscape, buildings, weather, multiple factors.
And as far as the degree of accuracy, what, if anything, does that tell you in regard to the location of the phone in reference to that degree of accuracy?
So it plots a point where it believes you are, and then the degree of accuracy says you could be in this bubble, but if it's way outside or way far away, it's all going to show by how well the signal strength is to the satellite. So, like I said, if it's a poor signal, it's going to blow out. It's going to show you could be in this giant circle. But as it gets better accuracy, it's going to shrink back down. It's going to say, no, you're right about here.
And to that point, or to elucidate that point that you were just speaking on, we'll get to this more in depth in a second, but at some point in 2023, did you go to 34 Fairview Road to conduct some GPS mapping?
Yes, I did.
And when you were in that area of 34 Fairview Road, what, if anything, did you observe with reference to satellite connection, cell phone connection, things of that nature, as far as the strength of the signal?
So on my way to work, I actually drive Fairview quite often, and being there in person with my phone, I'll go from 4 or 5 bars of service. When I'm there, it's 1 or 2. So that tells me that strength of signal there is not great.
It's the Canton Triangle, or maybe more precisely, the 34 Fairview Triangle. Well, here's a problem with that. He says that he drove past there like almost every day down 34 Fairview Road to go to work. Between January 2021 and 2023, how many times did you drive past there and not test the GPS signal? That's a potential issue because GPS signals can get stronger or weaker over time. I would imagine so, that there are other factors. So I don't know. I'm wondering if that's going to come up on cross. I'm very interested to see how this cross-examination goes, because they definitely are painting a very certain picture here. But we'll see. We'll see.
Now, turning back to this location data from Mr. O'Keefe's phone, you mentioned that you testified that at 12:25:36 a.m. It has a certain accuracy and it was traveling at a certain speed, correct?
Yes.
Now, what, if any, speed is recorded in this location data between that 12:25 a.m. and 6:15:36 a.m.?
Your Honor, may I just
Yes.
read? Thank you. What time frame exactly are you looking for?
What I'm asking is, what, if any, speed was recorded by the location data between that first 12:25:36 a.m. and 6:15:36 a.m.?
Oh, I'm sorry. I thought you were asking for before that. No, there's no real speed registered until the phone is found the next morning.
And so that would be at the 6:15:36 a.m. time frame, is that correct?
Yes, that's correct.
And what speed is recorded at that time at 6:15:36 in the morning?
It shows 0.24 meters per second for speed, and then with an accuracy rating of 7.58 meters, which is 24 feet.
Thanks. Now, sir, if I could turn your attention to May 8th, 2023, where did you go with relation to this investigation on that day?
I went to 34 Fairview.
And who, if anyone, went with you?
Trooper Proctor.
Of course.
Now, what was the purpose of going to 34 Fairview Road on that date in May of 2020?
We wanted to take measurements of where Officer O'Keefe's body was found, and then basically a diagonal straight line to the door, how the distance that would be.
I'm sorry, what? Y'all waited until May 8th, 2023 to do that? What? Why didn't that happen on January 29th or January 30th or sometime in February 2021? This is like 2.5. I'm like checks notes, like almost 2.5 years after the incident. A little under 2.5 years. That's when they first decided to measure that. Okay. All right. Cool. All right. That's all right. That's what we're going with.
And what, if any, tools did you bring with you, and what, if anything, did you use in the course of this analysis on this day?
So I loaded in the GPS points into a program that the CERT team uses called StarTopo. It's a GPS mapping program that you can view through an app. So that way I was able to see exactly where I was via the app. We also used one of the big long tape measures that's in like the big thing that would get us, from where we believed his body was to the front door.
And from that,
Sorry. Yes. Thank you, Sheena Ford, 2022. So yeah, I stand corrected. Not 2.5 years, 1.5 years. It's still a long time. It's still a long time.
as far as the determination of where Mr. O'Keefe's body was located, what, if anything, did you use to determine that?
As I said before, the photos and video from Sergeant Good of Canton PD and the Canton PD cruiser cam video.
So the cruiser cam video that's from Officer Sarah's cruiser, is that correct?
Yes, that's correct.
The one that shows where Mr. O'Keefe's body is when Officer Sarah arrives on scene, correct?
That is correct.
Now, with regard to those particular GPS points, what time frame did you start as far as your mapping was concerned?
We took the last, we mapped the entire route. So at the waterfall bar and then on from their drive on Dedham Street down to 34 Fairview.
And as far as these locations, how were they measured as far as what kind of measurements were you using in order to plot those points?
We loaded into Google Maps and just able to show it with a KMZ file to show exactly where he went.
And so what I'm asking is, as far as the GPS locations that you were recording, how were those measured as far as longitude, latitude? Is that how they were measured?
Yes, I'm sorry. Yeah, latitude and longitude.
And you started with Mr. O'Keefe at the Waterfall Bar in Canton. What time was that, if you know? 12 a.m. was the last point. And then that time frame when Mr. O'Keefe's native locations are putting him in the area of 34 Fairview Roads, when was that first time frame?
The time he arrives?
Yes.
About 12:24. I forget the seconds, but 12:24 a.m.
Now, eventually, when you had all of these points as far as the direction of travel, location data, all of those things, what, if anything, were you then able to do with those GPS locations?
I cross-referenced them with his health data and also mapped it out to see exactly where he would be.
Now, with respect to the data that you were able to recover, if you could describe to the jury sort of the path of travel starting with the waterfall as far as where Mr. O'Keefe's phone was, where it traveled in it, and where you noted it at various time points along that sequence.
Okay. So, as I said, at 12:12, it's at the waterfall bar. Then there's a 7-minute break in location data. When the phone comes back up with location data at 12:19, as I said, he's by Dedham Street and Cedar Crest Road. At 1:38 Dedham Street, right around there, 12:20 a.m., 34 Fairview is put into Waze. He then proceeds down Dedham Street, takes the left onto Oakdale Road. That goes to the end of Oakdale, takes a left onto Maplecroft. As he's going by Maplecroft and Pinecone Road, right around 12:22 and 14 seconds, was a data point listed that he's descending the stairs. So he's over a half mile away from 34 Fairview at this point. They go down Maplecroft, take a right onto Cedar Crest, all the way down Cedar Crest. They do not turn onto Fairview Road. It goes by Fairview, does a 3-point turn or turns around somehow, and then goes back to Fairview and takes a right, where it finally stops between 34 and 32 Fairview.
Y'all know what I'm going to do. You know what I'm about to do, right? If you've been watching this trial with us, you know what's coming. I can't not do it. I'm sorry, especially with him saying all of that without a map. I just can't.
I know a shortcut through El Segundo. Take the 105 West and exit on Culver. When you see the Zanko chicken on the left, turn left. Take Venice and follow it all the way down. Then you're in Marina Del Rey.
I just like giving that much direction when like we have no reference, we have nothing to look at, nothing to follow along with him. It's just like, like come on, like come on. Oh man. Okay. That was a nice little break for a second. All right, let's continue with it. So one that's like, Colin Albert, what are you doing here? All right, let's get back to it.
So at the time that health data is being recorded, and you cross-reference the GPS data with the health data from Mr. O'Keefe's phone, correct?
Yes, that's correct.
And so at the time that the phone has that recording of the health data descending, and is it ascending or descending, or how does that read in the health data?
I have in my report, and that's what's copied from the thing. It's ascending/descending stairs.
And at that point in time, cross-referencing that health data with the GPS location, where physically is Mr. O'Keefe's phone at that particular time?
Maplecroft by Pinecone Road, right at that intersection.
And has Mr. O'Keefe's phone arrived or been in the area as far as the GPS, specifically of 34 Fairview Road?
At that time?
Yes.
No, not at all.
And so from the GPS locations that you observed of the defendant's phone, initially the phone passes by Fairview Road and then reverses direction to come back, correct?
Yes, that's correct.
And then as far as between 12:25 a.m. and 6:15 a.m., there's no movement of that phone, correct? What, if any, movement did you observe following 12:25 a.m. until the period of 6:15 a.m.?
None until it was found at 6:15.
Now, you mentioned that you took a tool and you did some measurements as well. Is that correct?
Yes.
And were you able to ascertain then some GPS locations for where Mr. O'Keefe's body was found?
Yes.
And what, if any, measurements, excuse me, the accuracy of those GPS measurements in latitude and longitude, what was the accuracy of that?
Can I read the exact? Okay. All right. So from 12:25 and 30 seconds to about 12:35 and 36 seconds, the GPS accuracy is tight on him for the first few seconds and then blows out and encompasses pretty much the neighborhood. 34 Fairview, 32, 31, and I'll read the exact. It's 12:25 and 30 seconds. It has a 33-meter degree of accuracy, which is about 100 feet. That area encompasses 32, 34, and 31 Fairview. 12:25, 31, it's 200-foot measure of accuracy. That hits 31, 32, 34 Fairview. Basically almost all the houses around. 32 seconds, shrinks back down to 95-foot level of accuracy, hitting 32, 34 Fairview and the front yard of 31. At 33 seconds, it's 88 feet, again, shrinking back in as the signal gets better, covering 32, 34 Fairview, 72 feet at 34 seconds, 59 feet at 35 seconds, and then 52 feet at 36 seconds. So, as I said, signal weakens, it blows out, and then as signal gets stronger, it shrinks back in. The GPS coordinates themselves are all still right where Mr. O'Keefe's body was found.
And so as
Okay. Keep something in mind here. Remember that it's the prosecution here that has the burden of proof. They're the ones that have to prove this case. They're the ones that have to prove John O'Keefe was there at this moment. Karen Reed was there at this moment. This is when she hit him. She hit him with the car. This is how we know. This is how we prove it. This is what the jury can hang their hat on. As much data as possible to provide certainty is important for the prosecution. I don't know how much it helps the prosecution that the GPS is blowing out, less accurate, going in, more accurate, blowing out, going in, blowing out, going in. It kind of weakens the prosecution's case, in my opinion, because it starts to create this impression that maybe this GPS signal is not so accurate. And there are reasons why the defense wants to rely on certain aspects of John O'Keefe's digital forensics as well, to say, for example, that he took those footsteps in the house, to say that the pedometer was recording him walking up and down the stairs several times or things like that, because all of that looks like he's actually inside the house. And so they definitely want to be able to hang their hat on those. So which I don't think that actually requires GPS signal, now that I think about it. But, otherwise for the prosecution, they want to say with a certain level of certainty that the GPS data shows that he was definitely outside the house and not inside the house. So that's what they want to be able to show. But the more that they talk about how this is going in and out, I don't know. It starts to create this impression that maybe it's not that accurate. But jury might see it otherwise.
As far as, if I can take it back just for a second, the initial GPS coordinates that you marked as far as where Mr. O'Keefe's body was found, how accurate was that measurement as far as to itself where it was?
From what we had and then where we marked from, we believe we're in about 3 feet, because standing there, even with the app, it's not perfect. I'm not getting a direct saying that I'm right on it. So we believe we're within about 3 feet of exactly where he was found.
And from that air distance of within 3 feet of where Mr. O'Keefe's body was found, how far was that, or how far did you measure that to be from the front door of 34 Fairview Road?
In a direct straight line to the front door, 72 feet. Not accounting the stairs.
Now, from your review of that data that you were talking about from that 1235,
However, how do we know that they actually measured from the spot that John O'Keefe was actually in? That's also a really big question because number one, no one planted that spot or measured that specific spot on the day of. It sounds like everybody was kind of like, he was kind of over here, kind of over there. And the record keeping on where he in fact was is troublesome. And the two people who were there measuring this were not there that day. So him and Trooper Procta. So, you know, how do we 72 feet? Maybe it was, but maybe it wasn't. I don't know that I have any sort of confidence in that actually being reliable because
Red Solo Cup, I fill you up.
Right? Like the initial evidence gathering in the crime scene was god awful to include the location of where John O'Keefe actually ended up. So, all right.
1225 and 30 seconds through 1225 and 36 seconds when it fluctuates. What time period of that what time period of any of the time that you observed is it possible that John O'Keefe was actually anywhere near 34 Fairview Road, the house? Objection.
Ask it differently.
He's leading.
Within those fluctuating circles of GPS data that you were talking about, what time period did those encompass the actual inside of the residence of 34 Fairview Road?
It's about 3 seconds where it actually encompasses the inside of Fairview. That fourth second, it's right on the edge of the corner of the house. And then the fifth and sixth second, they're just showing the front yard.
And that time period, as far as those GPS data from those circles, with reference to the following time periods after those, what, if any, based on your training experience, what, if any, opinions were you able to draw from sort of that data?
So he would have to go from the GPS point that's listed. It would take him, you know, a second and a half to get to the house, and then a second and a half back where his body was found, where his phone was underneath him. He'd have to go about 48 feet a second when I did a velocity calculation, which is about 32 miles an hour, a second to the house, a second back. There was no GPS points ever showing inside the home, the backyard of the home. There's no lat and long listed. It's just the degree of accuracy from the GPS signal.
So 72 feet from where Mr. O'Keefe's body was found to the front door of 34 Fairview Road in order for him to be...
Sorry, we're going to cut off Lally's question because no GPS showing that he was inside the house, but you also have indicated that like all of your GPS like testing, even going out to 2023, that it's kind of a dead zone. Like that's literally what you said. That's why I called it the Canton Triangle, the 34 Fairview Triangle, because it seems like it's a bit of a dead zone. So how can you say that with any amount of accuracy that there's no GPS data showing? Well, okay, maybe there's no GPS data showing that he's inside the house, but that doesn't necessarily mean that he was not inside the house if the GPS data is not accurate. If it's a bit of a dead zone, for example.
Side of 34 Fairview Road during any of those measured timeframes, he would have to travel 72 feet and 1.5.
The objection sustained. The objection sustained.
Yeah, he's totally leading. I think maybe Lally got wind of the Lally tally, and he's trying not to use what, if any. So he's just resorted to just leading the witness. He's like, what, if any, is my solution so that I don't lead the witness? Let me just go ahead and lead them so that I don't add to the what, if any Lally tally. We don't want to get to 2000 today.
Sir, again, if I could ask you from Mr. O'Keefe's health data, as far as his specific physical location at the time that it indicates ascending and descending, how far away from 34 Fairview Road was it when it registered that?
It's over a half mile away. So Maplecroft to Pinecone Road.
In your opinion, sir, at any point in time from the data that you reviewed, did Mr. O'Keefe enter 34 Fairview Road?
I'll sustain the objection.
May I approach her?
Yes.
Okay. Sidebar. Oh, that wasn't a sidebar. That was just an approach.
Okay. You recognize those, sir?
Yes.
And what do you recognize those to be?
These are the plotted points I did through Google Earth, the maps, and then through LexisNexis, the track system, the GPS range and coordinates.
And the LexisNexis track system, if you could explain just a bit to the jury as far as what that is and how it's used to create these documents for you.
It's similar to that Startopo program I used. It's a desktop-based GPS program. You put the points in, and then it will map them out and create, like I said, a KMZ file for you, so you can load it into Google Earth.
Yeah, approach on.
Yes.
Almost teaching.
Okay. Thank you. 6:30.
Yeah, return to the witness, John.
Yes.
With the court's permission, may I publish this, jury?
Yes.
Ms. Gilman, if you could take that down. I have a moment, John.
Yes.
In fact, Trooper, if you're more comfortable standing for some of your testimony, you certainly can.
Thank you, Howard.
Gilman, if you could enlarge that just a bit. Now, Trooper, there should be a laser pointer up on the stand before you. If you could, first of all, let me just ask you, recognize what's up on the screen now as the next exhibit.
Yes.
And again, if you could just explain to the jury sort of what we're looking at in this slide, and then using that laser pointer, if you could, direct the jury's attention to what, if anything, of significance you have in this particular slide.
So I took an overview of the town of Canton. So this here is the GPS route, and then down over, I can barely see. Let me just look on the map here.
We can't see it either.
It's not much better. The waterfall bar is right up. I can't really tell honestly from this, but it's on Washington Street. That's down here. I'm sorry. That's why I included an overview of everything, so you could see the full range from the time period with that GPS locations.
It would have been helpful if they had plotted some points on there.
Your Honor, if I may, just if it's possible, I don't know.
Keep your voice up.
I don't know if this is going to work any better, but if I could ask if we could turn the lights back on just so the witness can see
Sure.
what's before him, and then. With the court's permission, I think the map is still viewable to the jury, and now the witness can actually see the exhibit.
Can everybody see it?
And so again, sir, Trooper, I'm sorry. Now with visible before you,
Okay, so maybe these will be reference points for us. All right.
we could just indicate again what we're looking at in this.
Yep. So when you zoomed in, it actually closed it out, but it's down over here is the waterfall bar. There's a couple of points there listed. And then right around here is when the GPS tracks go, and their route, once Waze is activated, down to 34 Fairview. There is a zoomed in version of by Fairview.
And Ms. Gilman, if I could have the next slide.
So
Sir, what are we looking at in this slide?
yep. So this is the track. This one shows the 12:22. 12:22 and 14 second GPS point where right here where the little arrow is. That's exactly where they were when the phone is registering the ascending, descending stairs, like listed in Cellbrite.
If you could, using that laser pointer to illustrate to the jury where that point is in relation to where 34 Fairview Road is.
Yes. So this is where they were with the ascending, descending stairs. They would continue down through this little piece here, take the right onto Cedar Crest, they continue down Cedar Crest, missing Fairview right here, and then turn back around and then come to the house.
And Ms. Gilman, if I could have the next slide. And Trooper, what are we looking at in this slide? Specifically, if you could explain to the jury as far as the blue circle with the attached to the
If you could look this way, please.
attached to the LexisNexis tracks, could you explain to the jury what that is and what that signifies?
Yeah, so as I said, we loaded this in through LexisNexis, and it gave us the GPS points for the route. The point is 348. I just want to double check. Yeah, point 348 is at 12:25 and 30 seconds. The blue circle is the estimated range, so how well the signal for the GPS is. And 34 Fairview is right pretty much by that L.
Gilman, if I could have the next slide.
Why would they?
Yeah, there we go.
If the whole point is to show 34 Fairview and like his location related to 34 Fairview, why would you place that on top of 34 Fairview? Like, can't you move the box out of the way? Whatever.
Trooper, is this essentially the same image, a little bit closer without the graphic as far as the LexisNexis?
That's correct. This is 34 Fairview right here, 32, and then again, this is where all the points are for the duration.
As far as the blue circle that's up on the screen, what does that represent as far as this particular point in time for this GPS point 348 at 12:25 and 30 seconds?
Yes, this is as I said before, the range of accuracy due to satellite strength. So as I said, it blows out as it loses strength, and then will come back in as it gets better signal.
Mr. Gilman, if I could have the next slide. Again, Trooper, what's up on the screen? What are we looking at this as far as 12/25/31?
Same area where the 348 is. This is part 351. Again, as you can see, strength of signal blows out and encompasses almost the whole neighborhood, of all the houses around.
And Ms. Gilman, if I could have the next slide. Again, sir, is this the same GPS point of 351, number 351 at 12:25 and 31 seconds?
Yes, it is.
And if you could, again, just explain to the jury what we're looking at in this slide.
Same thing, just the degree of accuracy and the strength of the satellite signal to Officer O'Keefe's phone.
Ms. Gilman, if I could have the next slide. And again, sir, if you could explain to the jury what we're looking at in this slide, what time frame we're talking about.
Yep, this is point 349 at 32 seconds. Again, latitude and longitude, they're all right in the same area, and that's that.
Ms. Gilman, if I could have the next slide. Again, Trooper Guarino, is this the same GPS plotting point in the same time frame of 12:25, 32 seconds?
Yes, it is.
And again, if you could explain to the jury what we're looking at in this, in particular in relation to the earlier slides with reference to the accuracy that you talked about.
Yeah. So again, the accuracy blew out as it lost signal, and now it's shrinking back in as accuracy gets better.
Ms. Gilman, if I could have the next slide. And sir, what GPS point or what time frame are we looking at in this particular slide?
This is 12:25 and 33 seconds. Again, same area, lat long, right in the yard of 34 Fairview.
And Ms. Gilman, if I could have the next slide. Trooper Guarino, is this the same GPS point of number 348 in 12:25 and 33 seconds?
That's correct.
And again, if you could explain to the jury as far as the accuracy and what we're looking at in this.
Yep. So I believe there actually wasn't that much of a drop off. Yeah. So it went from 88 feet to 72 feet. So the circle still doesn't look like it really shrank much.
Ms. Gilman, if I could have the next slide, please. And again, Trooper, what time frame and what GPS point are we looking at in this one?
This is 12:25 and 34 seconds. Again, same thing right there, the corner of 34 Fairview and 32 Fairview.
The last like 10 slides have all been at 12:25 a.m. It's like 1 second later, 2 seconds later. So I don't know what they're trying to show in terms of his movement or what, but like, I mean, was he sitting in the same spot at 12:25? I don't know what they're trying to show.
If I could have the next slide, please.
12:25 and 34 seconds.
This is the same GPS point number 350, 12:25 and 34 seconds. Is that correct?
That's correct.
And again, using that laser pointer direct your attention to what we're looking at in this.
Yep. So 34 Fairview is here. So as I said, this point here is the last one where it sort of cuts out the little corner of the house, but everything's still showing directly. This is where it's believed to be.
Ms. Gilman, if I could have the next slide. What
1
GPS
second
point,
later.
what time are we looking at in this one, sir?
This one's 35 seconds, 12:25, 35 seconds. Same thing. Again, GPS point still saying it's right there where his body was. But again, it dropped from 72 feet of accuracy down to 59 feet. So it's going to show the outside only of the house.
So the signal strength is strengthening at that point, is that correct?
That is correct.
If I could have the next slide, Ms. Gilman. Again, sir, same GPS point of number 346, the same time as 12:25, 35, is that correct?
That's correct.
Ms. Gilman, if I could have the next slide. Mr. Guarino, with regard to this slide, what GPS point is being depicted and what time frame are we looking at?
This is GPS point number 345, and it's 12:25 and 36 seconds. Again, showing that the signal strength has, again, grown and gotten better.
As far as growing on better, what accuracy, what degree of accuracy in feet are we looking at?
This is within 52 feet.
And Ms. Gilman, lastly, from this group, the next slide. And again, sir, this is the same as the previous slide, GPS point number 345, 12:25 and 36 seconds.
That's correct.
And again, if you could, using the laser pointer, just illustrate to the jury what we're looking at.
Yep. As I said, there's any plotted points anywhere other than right in this area for the rest of the night. This is where it stays, and there's varying degrees of accuracy, but there's nothing ever showing it anywhere else in that neighborhood.
May I approach, Ron?
Yes.
you have that last document?
I just gave it back.
If you could take a look at that and look up when you finish.
Yep.
Sarcodoodle,
You recognize
yes.
that, sir?
Yes, this is a second map I created with the Cellbrite locations from their native locations. The previous one was from Axiom. So I used both programs to map it.
Why did you use both programs, sir?
As I said, Axiom showed movement and degree of accuracy where Cellbrite doesn't. It just gives you the native locations. I use two programs so I can corroborate what I'm seeing in one is the same as the other. Because if not, then I need to find out why.
And as far as the information from one program to the other program, were they corroborative of each other?
Yes.
May I approach, Ron?
Yes.
I'm going to seek to introduce and admit the next exhibit. No objection.
There's one.
This is feeling a little bit loosey-goosey here. Definitely curious to hear Yannetti's.
May I return to witness stand?
Yes.
With the court's permission, may I publish this to the jury?
Yes, with the lights on still?
I think so. Thank you, Mr. Guarino, starting with the first page that you have before you, first of all, do you recognize what's up on the screen as the first page of that next exhibit?
Yes, sir.
And again, if you could, using the base pointer you have before you, direct the jury's attention to what, if anything, of significance you observed in this first page of this next exhibit.
Yes. So again, this is from the Waze app. They're tracked from 234 Fairview down Cedar Crest again, returning back here. So that's just the bottom half. I just wanted to get a closer view of where the GPS plots were from Cellbrite.
And the next slide is going to. And again, sir, if you could explain to the jury what we're looking at in this slide.
So the purple dots are the GPS points and the route taken. As I said, goes up to, I believe that's 51 Cedar Crest, and then reverses back. And then this is the final point. It's right here. 34 Fairview is right here. There's a little yellow push pin on it.
And yes, sir, I'm sorry, just from the timing of the plotting of the points, purple dots that you have there, you could just, using the laser pointer, direct the jury's attention to the path that Mr. O'Keefe's phone takes in reference. If I could ask you first, if you could just illustrate to the jury this particular slide, where is 34 Fairview?
Right here.
And then if I could ask you with the laser pointer to direct the jury's attention to the path of Mr. O'Keefe's phone in sequence, sort of how it travels and arrives at that location.
Yep. As I shown, goes down Cedar Crest, misses Fairview, goes up to here by the house with the pool, turns around, comes back, takes a right onto Fairview, and then stops ultimately right in between 34 and 32 Fairview, where there's like a flagpole and a fire hydrant right there.
Tell me if I got the next slide. And Mr. Guarino, direct your attention to this slide. What are we looking at?
Again, I cross-referenced it with the points. This is Pine Cone Road, and then Maplecroft intersects here. And this is the ascending, descending stairs point in his phone. Doing a Google Earth elevation check. There's about a 20-degree dip, and then it goes up. And then as you go down Cedar Crest, the hill is about a 50-foot elevation change again. So it's pretty significant.
And so I'm sorry, sir, as far as the elevation change that you're talking about, how is that measured and how and where is that in reference to what's picked up here?
So again, like I said, in this area here, there's about a 20-foot drop. And then as you go down Cedar Crest, that hill, it's about 50 feet. This spot here is the ascending, descending stairs. So as I said before, he doesn't have an iWatch on, so it's not collecting that great health data. It's still acting as a pedometer. So again, whatever movements he's doing is triggering something in the phone as he's ascending and descending these hills. Essentially, it could be tricking the phone into thinking it's stairs.
Ms. Gilman, if I could have the next slide. Mr. Guarino, what are we looking at in this one?
This timestamp is 12:19:32 seconds. That's when the phone initially starts creating the GPS points before Waze is activated with 34 Fairview searched. So this looks to be the time Waze is actually opened up.
And so from the purple dots that are depicted on the screen, as far as where is Mr. O'Keefe's phone at 12:19 a.m. in reference to 34 Fairview?
12:19 is right here. 34 Fairview is down all the way here. Number, you can't really see, but it's right in the bottom corner.
And the next slide.
This is the same map, but just minus the tracks, graphic.
I'm sorry, Trooper, I lost track of what page we're on. Is there any other pages in that exhibit for you?
No, that's the last one.
Really quick, this one question here. Michelle Northern. So was her 3-point turn when they turned around before she dropped him off? That seems to be what they're suggesting. but that wasn't what I thought that people had testified about. I don't know. There was testimony about like seeing the tracks. It looked like it could be a 3-point turn. So this seems to be what the prosecution at the very least is saying. All right.
Approach this retriever.
Yes.
Maybe you approach.
Okay.
Okay, sidebar.
Pull back in the jury deliberation room. We're going to take our morning break. We of course have to stick around, but you can file out when the jury does. So jurors, the lawyers and I have something that we have to do, so it'll be a little bit longer. I hear it's nice and cool back in the jury deliberation room. So we're going to take a half an hour, 45-minute break here.
All right.
Will we be seeing any of this the lawyers are having to do? So what's happening now, they've got a recess, but they're going to have a bit of a longer recess. It's going to be 30 to 45 minutes, according to Judge Bev.
You are muted.
So we definitely have time for questions. All right, we've got the fan. All right. So actually, before I do that, let's get caught up to live. So we started off about 20 minutes behind. Now we're caught up. Yep, this is live. Okay. So we'll put that on in the background while we go through some questions. All righty. Let me get over here. I'll get this one really quick. Tatum Reed, is the jury voting now guilty or not guilty? No, not by a long shot. The prosecution still has not ended their case in chief. They still have a couple witnesses after this one. This witness actually hasn't even been cross-examined yet. So we definitely have time before the prosecution closes their case in chief. And then assuming that the court does not dismiss it upon the defense's motion, because they are definitely going to be moving to dismiss the case after the prosecution's case in chief. Most likely they won't succeed on that. It's very, very uncommon to win on that. But then the defense will have their case in chief, and then it will go to the jury to deliberate. So we still have quite a ways away, based on what Judge Bev said before. She said that she anticipated that they would get to deliberations before the end of June. So next week. Today's the 20th. Yeah. Got a little over a week. I think we can get there. I think we can, based on where we are. Okay, let's go through more questions here. And the rest of the new ones that are coming up, I'm going to be answering as they come up. Darth Horse, Legalbytes, how often have you ever seen a criminal trial involving death leave the medical examiner for the last witnesses? I can't say that I ever have. There might be some others that are much more experienced in criminal cases, criminal trials that have. I wonder if Emily D. Baker has, or Ian, for that matter, Ian Runkle, or Natalie Lawyercheck. All of them have extensive criminal trial history. But for me personally, no, I haven't. Mike Olson, question: when CW has said during voir dire that he or she has gotten all he or she wanted, do a judge ask for more and hint to prosecutor that they can/should ask for more exclusions, like Auntie Bev? No, I mean, the judge is also able to ask questions. I mean, that's why she asked questions herself, because at the end of the day, it was going to be her decision to either allow this testimony in, not allow it in. So, you know, because of the fact that there wasn't any jury present for that particular proceeding, you know, she didn't need to maintain the same kind of decorum that she normally does when the jury is in fact in the courtroom. So, she was able to actually just ask these witnesses questions directly. So if she thought that there was anything that was kind of missing, she could go in there and ask that herself as well. Question from KJ Height. Why would you call someone you hit, and why would they answer the question if they were hit? Yeah. Well, I think the prosecution's theory is that she called him to basically cover up her tracks. And she called him, well, either to cover up her tracks or because she was still like livid and just like calling him like, I don't know. I don't know. Like in other words, like she was still enraged and like still wanted to just like rage at him even after hitting him, I suppose. That or covering her tracks. I'm not sure. I'm not entirely sure which one of those that they're going to go with. I don't know. We'll see. We'll see at closing arguments what they basically say. Majufi, Alita, the judge says only a doctor can testify as to the cause of an injury, but didn't she let Trooper Paul do just that? Yeah. Yeah, I mean, yes. I mean, he couldn't testify like specifics about the injury itself. So I'm wondering if that's what she means. Like going into, I don't know, like very detailed specifics, but he was able to say like, yeah, well, I think he was hit on his shoulder or on his upper arm or something, and like that's where he was hit, and then that's how he ended up, getting in Jackson's words, pirouetted. But he basically turned and went sideways because of that. So like you have to be able to testify on that to a certain extent, at the very least, because the prosecution has already been able to do that. Let me see if I've gotten all of these here. Okay. Baz 80s. It proves her innocence. No, if she's leaving messages to cover up, wouldn't she pretend to be nice? I would think so. Yeah. Yeah, you would want to establish a different kind of a tone if you're trying to cover that up. So maybe the argument here is that she's still enraged and she's like in this like mindless rage kind of thing. To me, it doesn't fit. It doesn't feel like it fits. Mew Mew, a Legalbytes question, hypothetically, if she was crazy mad and hit him, could she go with a temporary insanity plea? Well, I understand what you mean by that, because it does seem like she has actually like lost her mind at this point, based on the testimony that we've heard from Carrie Roberts and Jen McCabe and these voicemails and other, and also from Matthew McCabe as well. And from the testimony of all of the other people that were there at the scene around 6 a.m., the first responders and whatnot, it definitely seemed like she actually lost her mind around that time. And so, but the thing about a temporary insanity plea is it has to go, like, it's pretty hard to like prove all of that, to like show that she didn't have like her mind in the right place. Like, usually there's some sort of a diagnosis that you would like to have with something like that. But also this, I guess if you want to call it like an episode of her, like essentially losing her mind, it seems like that winds up and then it results with that in the hours that followed. So I definitely see her winding up, and that she starts winding up kind of earlier. But yeah, I don't know. I don't know that there's enough for a temporary insanity plea for my part. All right, let me see here. Moving on down. SSS, a question at this point of the trial. I'm still confused by the prosecution's case. When this part is finished, could you put together a summary of their arguments? I'm curious to know what, if any, have merit. The prosecution's case, their theory, their narrative, I agree, is very loose. It's very loose. It hasn't always been clear exactly what it is that they're trying to say with a lot of the details that they have entered into evidence. But yeah, I'll do my best. If you guys want to, to hear a bit of that. Alexandra Houghton or Houghton. I hope one of those was right at least. Why did the CW decide to go with second degree and not vehicular manslaughter? Seems like it would have made their lives easier. To be honest with you, I don't know. I know that they did bump up the charges at one point early on after this investigation. But yeah, I don't know what their reasoning was. I came into this case a little bit late, like just before the trial began, so I don't know. I don't know like their actual reasoning if they provided any sort of public reasoning for it, other than like they said that they like encountered more evidence that like shows more guilt or something like that. Triker question. Lally keeps giving gifts to the defense. I guess he doesn't believe in this case either. 53 freaking calls, a real butt dial where you can hear so much pain in her voice. What is his issue? I don't know. I mean, he might be thinking that it actually is helpful to his case. I don't know. Oh, here's a good point. Jillian Spinotto, they did it to try to get her to take a plea. Okay. Yeah. Bumping up the charges. Yeah. Sometimes prosecutors will also overcharge in order to try to negotiate a plea deal, which is dirty. I don't like it. But yeah. Alrighty, Buttercup 203 question. Did John connect to Albert House Wi-Fi? There doesn't seem to be any evidence of that, but we'll see on cross-examination and with the defense experts. So we'll find out. Fairy Moon 71. How does the house not have a Ring camera? Not every house does. It could be that, being a police officer, how Ring cameras can be accessed by other people, secretly when they shouldn't be getting access. I don't know. There could be a number of reasons why they don't have a Ring camera. My big question is, how does no one in the neighborhood have a Ring camera that was used? I mean, I've talked a lot in this case about the Caitlin Armstrong trial that was out of Austin, Texas, the cyclist love triangle murder trial that was last November. And that one, they used a lot of Ring footage to even show her Jeep driving by, and then they were able to plot that with the GPS of her infotainment system and her phone, I guess, was off at that point, but it was like really, really good detailed corroboration that they were able to get with the Ring footage and all that kind of stuff. And it could be, well, this incident happened in 2022. I do remember hearing that Ring used to have a much looser policy on giving out Ring footage data to the police, but that in recent years or over the last year, I think, if I remember correctly, I remember seeing an article about how they were changing their policy to require a warrant because there were a lot of complaints about them just kind of giving away privacy of its users. So I don't know. Maybe that has something to do with it, but then again, this is from January 2022, so one would think. Tori Matthews question. John's phone was with his body. If they mapped out his steps, would his phone not show him in the street, then fly 30 feet through the air, as Trooper Paul said? Although the prosecution's stance on the pedometer of the phone or the steps in the phone is that it's just not accurate, because they were pointing out, well, this point where the phone says that he was going up and down the stairs, he was at this point on the route, and the Waze data tracker shows that they in fact were not even at 34 Fairview Road yet. So there was that definitely seems to be the suggestion. It's just overall the pedometer in the phone is not accurate at all. Narcy question: what time was Jen's text to John before they got there, and when she said to pull behind her? That actually is a really good question. I have not lined that up. I can't remember exactly what time she texted him for that, but that would be really interesting to see those side by side. Fairy Moon 71 question: any guess if Karen will testify? I don't think so. I don't think she needs to. JC, Legalbytes, is it me or does he sound really nervous? He doesn't sound as nervous as Trooper Paul. However, he did sound a little, somewhat, and it's understandable because being a witness in any kind of a trial can be nerve-wracking, regardless of whether you are an expert witness or you're testifying as an expert or as a layperson. But I would imagine also knowing that you're going to get cross-examined by either David Giannetti or by Alan Jackson would also add a little bit of a stress level for that as well. Also, Gunnar Dennis, thanks so much for the super chat. Was John flying through the air registered on GPS? I don't think so. I think that what they were able to just show is that he was basically there at 34 Fairview Road, and they're maintaining that the GPS shows with a reasonable level of accuracy that he was outside the house, not inside the house. It'll be interesting to see that tested on cross, though, so we'll see. All right, more questions here. Shannon, wish we could see Alita in court. Any footage? No, there's no footage of me in court from previous cases. It's also been a few years since I've been living overseas also. So yeah, but no, nothing on camera for sure. From my time litigating cases in court. XMO, at the end of the trial, can the judge sanction or sentence the troopers if the evidence is pointing towards cover-up? No, that would have to be an entirely different like charge or entirely different investigation. That wouldn't be something that the judge would just sort of like add on as well here. All right, 1 second here. Okay, we've got some more questions coming in. All right, Shannon, Legalbytes, morning. Grand jury, less doubt needed to get through. I think your question, if I understand it correctly, is does it, like, what is the standard in order for the prosecution to be able to proceed through a grand jury for an indictment? Yeah, it's a very low standard for an indictment is what I would say. Definitely much lower than a conviction. The standard is super high in order to secure a conviction. It's you've got to convince the jury beyond reasonable doubt. If they have any amount of reasonable doubt, that means doubt that's based off of common sense, based off of logic, based off of basically anything more than mere speculation. That if they have any reasonable doubt about any material element of the case, that they should not convict. So the difference between that and the grand jury is a lot. I mean, the common adage is that, if you really wanted to, you can indict a ham sandwich. It's that easy. Typically, the defense doesn't even play any kind of a role in the indictment. It's just the prosecutor and the grand jury, the people that are sitting on the grand jury. It's a conversation between just him or her and them. So only in some places like New Mexico, I recently learned because of the whole Rust cases that indictments are a little bit different there. They have a few extra protections there, but it seems even there that it probably is a relatively easy thing to secure. Is an indictment. Joseph Zale, thank you so much for the super chat. If KR was JO's ride for the night, why did she freak out when he wasn't home at 5 a.m.? How did she expect him to be home? Doubt anyone at party was sober. I think that the issue for her was not so much that he wasn't home at 5 a.m., but that he also wasn't picking up. Because, I mean, keep in mind, earlier during the day when they had that argument, and she kept calling him like 18 times, and all but 3 of those calls were either ignored or rejected. That seems to be the kind of thing that winds her up even more, based on the text messages that we saw, based on the overall sort of flow of that communication between the two of them. So, I referred to this during the last testimony day. So on day 26, when we were going through those text messages, I said, I said that this sounds like one of those relationship cycles where this time we've got some movement here. This sounds like one of those relationship cycles where the two parties, the two individuals are in sort of this cycle where one of them wants to get really close to the other because they're feeling very vulnerable, and their way of relieving that anxiety is to get comfort from the other person, get more intimacy. But then the other person in that same moment is thinking, I need avoidance, I need space. And so those two are completely incongruent. And if they don't understand what they need and what the other person needs and why they need it, you know what I mean? You can end up in just this vicious cycle where you don't really get a common understanding, and then ultimately a resolution to it. Like that's what it seems like that whole issue was. So I think for her, it wasn't so much that he wasn't home by 5 a.m. It was more the fact that he hadn't been picking up her calls. He hadn't been responding to her text messages. That's what that seemed like to me. Okay, let's get some. I'm going to do rapid fire through these questions now to try to catch up, because now that court is back in. Shannon, oh, sorry, we already got that. Fairy Moon, wait, didn't he say he never saw the phone, only the extraction? That is correct. KJ Heights, so he could have been in the house when it blew out. Possibly, but I think that his point is all of these were like 1 second, 2 seconds apart from one another. So, he's not going to have like suddenly the next second be inside the house, right? It's going to take some time for that to happen. Stephen Dolgos, novice here. What is the clerk beside the witness stand putting in front of her mouth all the time? That is the court reporter. She's talking into it to essentially take the transcript of the court proceedings. Typically you see people typing for that. It's like a special kind of typewriter just for court reporters, but this is another method of doing it. Michelle Northern, question, in the Lexus data that they're trying to imply when she hit him. It seems like it, but I don't see it. I don't see the connection. It just like he's there for a bit, but all of that is during 1 minute. I don't know. Logan, Legalbytes, jurors, mom and dad need to talk about things in private. Yeah, that definitely seemed like it, right? Shannon, question, if Karen had shown tears at her calls, better than stoic. Yeah. I mean, but keep in mind, people respond to trauma, to grief in all kinds of different ways. So, that's another thing that if people need to, generally speaking, keep in mind. There are a lot of ways that people either internalize their feelings or express them outwardly, or just in automatic response. And people are different. Holly B, how many witnesses does Lally have left? So I think 2, not including this one, Guarino. Draco Amy, question, is it better for Karen to have the case dismissed or to be found not guilty? Either way, double jeopardy is attached. So she can't be retried either way. So, yeah, I think it's, I don't know, probably better for her in terms of like stress levels, attorney's fees, having to go through more and more and more days of trial. It's probably better for her to have the case dismissed. But in terms of like public exoneration, getting her story out, maybe it's better in some ways on like the social public kind of front, in the court of public opinion, to go through with the full trial. But undoubtedly, I would say that, in terms of like the overall experience of trial, it's better to have it dismissed sooner rather than later. El Boric, can you recap the expert's decision? Morning stand-up makes me miss the first 30 or so. Thanks. If you mean the decision on the expert witnesses from the voir dire, I'm not sure exactly what you mean by the expert's decision. If not, I mean, that's definitely going to be in the recap. So we'll save that for the recap. Splits personality, wouldn't health record capture J.O. flying 30 feet? Perhaps. If they're trying to be that precise, I would think so. Mike Olson, Legalbytes, yes, but CW said, I have gotten what I asked for. And then judge found something she thought he should have a problem with. Or, lawyer, Peter is a defense something. Oh, defense lawyer. and therefore was on defense side. Are you on prosecution side? No, I don't think Lawyer is on anybody's side. I think that he's always been very, very neutral from what I've seen in his coverage. I mean, he definitely shares his opinions, but I don't think he has an inherent bias before he goes into any kind of a case. He will come down on the side of the prosecution in a case, and sometimes he'll come down on the side of the defense in another case. So, but really what he cares about is fairness and ensuring that the judicial system actually works. So, and same thing with me. Like I'm not on either side at this point. I mean, other than I do think that the facts seem to be more in the defense's favor at this point. The prosecution, I still just, I don't see them proving this case beyond reasonable doubt. I just don't. But I mean, okay. So she may have found something that she thought that the prosecution might have a problem with. I don't know. She's ultimately the one that was making the decision anyway. So if she saw something, she was going to make a decision based on what she saw anyway. You know what I mean? I don't know. So I have less of an issue with that. Legalbytes, I saw the exculpatory pic of Indy. Case dismissed with prejudice. So cute. Show the puppy pic for sure. You know what? Remind me at the end. I will show that either at the end of this session or the afternoon session, and I will definitely show the exonerating photo of little Indy when she was a 4-month-old puppy. She was so cute. Mike Olson, Legalbytes, all in fun and games, not too serious over here. Definitely understand that. Rubber Duck 77 question. I went back to check the last timestamp. She's at the house 12:25. She's on John's Wi-Fi at 12:36 with Google Maps. Says 6-minute drive, but doable. But is that too tight timeline for the jury? I mean, yeah. If they're trying to say that she hit him at 12:25, actually, that's 11 minutes. I think what I calculated was on Google Maps when I looked it up, it was like 6 to 7 minutes to get there. With the snow, 11 minutes. I could see that possibly. So I guess that's their theory ultimately. Julia Westmoreland, what happens to Karen if the trial goes past June and ends up in a mistrial due to insufficient jurors? Then there's a possibility, if there's a mistrial, there's a possibility of a retrial. But that's up to the prosecution. So I hope that doesn't happen. Dana Mazalziv, question. Oh, and by the way, though, in terms of the jurors, there still are 3 alternate jurors at this point. There's 15 total. 12 of them will be on the jury. So I mean, you never foresee when a juror is going to be excluded, going to be excused. But there are, I don't know, in my opinion, I think that there are plenty of jurors left that if something does happen to 1 or 2 of them, we're still good. Dana Mazalziv, question I joined recently. Sorry if this was covered. Did the judge decide on the defense experts? The judge did decide on the defense experts. They're all coming in. So I guess I could have said that earlier. I think it was Legalbytes that asked the question. The defense experts are all coming in. There's some limitations on some of this stuff that they can testify to. That's the TLDR version. Too long, didn't read. Tatum Reed, so she did hit him, like him, the person, or she hit his car. That's still very much at issue here from both sides. Life on Makeup question. How long before Lally puts in a lane and just shrugs and says, I'm trying. I don't know. It could happen. Let me see. Oh, not here. Let me see here. Okay. Florida Dad, thanks so much for the super chat. I missed it after state's cell phone expert. Am I wrong, or did the state establish only person calling John O'Keefe's phone and looking for him was Karen? What about all the other concerned people? Well, I think they all basically testified that they didn't know about it until Karen started calling. But yeah, that kind of makes sense. If they had his phone number too, why didn't they call him? Yeah. KJ Height question. Didn't Green say, oh God, Kami? That was, I thought it was Lally at first, that was a hot mic moment for Lally, but I think it was actually this witness, Guarino. Hazar is 1683. Based on the voicemail, it does seem like KR was a convenient babysitter. Didn't one of the Albert and McCabe ladies call her that? It would seem they knew the relationship dynamic, which is unfortunate. So that was Carrie Roberts who had said that to Jem McCabe. JC, I would also be hella nervous, but especially if I knew I wasn't on the right side and that the FBI was waiting. There's a lot of reasons. There's a lot of reasons to be concerned as a witness in this trial and in any trial, to be honest with you. Sheena Ford, can you be a lawyer overseas? I know you mentioned moving next year, so maybe not something you'll pursue. Well, there are ways of practicing, remotely and things like that. But if you need to be inside a courtroom, it makes things very, very, very difficult. Shannon, wow, do a teaching vid on grand jury, no pressure. Yeah, I mean, I've talked about it in some instances. But yeah, maybe I'll do one that ends up kind of focusing in a little bit on grand juries a little bit. Stephen Horton, Legalbytes out on dismissed versus not guilty. Would they have a different impact on any possible civil cases? Not necessarily. No, because they both would be, if there's a guilty verdict, that would definitely have an impact on a civil case because the burden of proof is much higher in a criminal case than it is in a civil case. So if the prosecution successfully proves the case in the criminal case, it definitely meets the burden in a civil case. So it makes it that much easier for, say, the family to sue Karen Reed if she is also convicted already. But if she's not guilty, that kind of brings an open question because the case maybe not, like maybe the case is not so strong that it doesn't meet this burden, but maybe it meets this burden and it's like somewhere in this zone in between. Do you know what I mean? Does that make sense? So that could also be, but it being dismissed versus not guilty, that I don't think that would have any bearing between those two. James Games Classics, Legalbytes, has judge allowed defense experts? Sorry, missed a beat. Yes, she has. Just limited. Sheena Ford, Legalbytes, if there's a mistrial, will the prosecution have to pay for the experts to come back again? Everybody's going to have to pay for everyone. Yes. Yeah. All of the fees, lawyers' fees go up, because there's more time spent on the case. There's more analysis. There's, witnesses have to come back. You've got expert witnesses that have to come back. There's so many reasons why a mistrial is such a pain in the butt. So, and that is, state resources as well. Resources for the Commonwealth as well have to be spent. And that's why there's a serious question as to whether or not they would actually do it. Hussar 1683. So Lally's play was to highlight women's insecurity in front of a 9-woman panel. I wonder how that will go over with the jury. Most have been scorned this way with enough life lived. It's a good question. And I don't know that I have a very concrete answer because at the same time, there also is a tendency for women to also be much harsher on women than men are on women. And that sometimes then women are on men. That's not a concrete rule. It's a somewhat of a tendency. I say this because, when it comes to like SA cases, generally speaking, where a woman has been raped, for example, or there's an allegation of that, you don't necessarily want women on the jury because sometimes it hits a little bit too close to home. And so there's a lot of women that would look at the actions of the alleged victim and say, well, I wouldn't do that. I wouldn't do that. I wouldn't put myself at that kind of risk. Why did she do that? You're much more likely to be more critical of the victim in a situation like that. And that's not unique to women. I'm sure there are similar tendencies of men being more critical of men in certain contexts as well. So, sometimes having women overwhelmingly on a jury like this can be beneficial to a defendant like Karen Reed. In this kind of situation, I haven't really thought about whether, how much of a benefit or a hindrance that would be to her. But I will say that something like the Trooper Proctor text messages are definitely something that having a very heavily female jury can have a positive impact for Karen Reed, I think, because that is an instance where those women placing themselves in the position of Karen Reed are going to feel like, I don't want to be violated in the same way by the police. Like, what is this person do? You know what I mean? So, so there's, in that kind of a situation, I think it's helpful to have a lot of women on the jury, but highlighting her insecurity, Yeah, I mean, I don't, that could be another situation where it's actually beneficial. I don't know. I haven't thought too much about it though. I'm gonna think about that for a bit. Mike Olson, next time I need a lawyer in Sweden, I'll ask for you. You get paid by the state, and I am always guilty anyway, so it would just make it from bad to fun. Well, thank you so much, Mike. I appreciate that. Although I'm not licensed in Sweden, so I can't practice there for sure. Okay, let's continue with the testimony now that we are back from the recess.
All right, so Ms. Gianetti, did that give you enough time?
Oh, I had enough time. Yes.
Okay. All right, so Ms. McLaughlin, why don't I hear you just briefly?
Okay, so now we're going to have
If you could frame this, or Mr. Lally, whoever wants to.
Yeah, sure. The Commonwealth is moving to introduce a Google search the defendant conducted at 1:27 p.m. on January 29th, 2022. The Commonwealth would argue that the probative value of this Google search outweighs any prejudice to the defendant. The search in question is at 1:27 p.m. before the defendant had spoken to law enforcement. She conducted a search for DUI attorneys. The Commonwealth thinks that this is appropriate for the jury to hear, as it rebuts the Bowden defense that the defendant has laid out. Not that she did not intend to commit John O'Keefe. The defense has been that the defendant is essentially what's been represented in opening court was framed that she had no intent or opportunity to commit these crimes. Further, that she was not intoxicated at the time. So the Commonwealth feels that the probative value significantly outweighs the prejudicial value. It goes to her state of mind at the time that the search was conducted.
No freaking way.
Further, it also rebuts that there was
no freaking way
any impropriety in the police investigation, or that, as the defense has put it, that the police did not search any or investigate any other potential culprits. It also would go to the defendant's contract.
That is on the same level of saying that someone invoking their Fifth Amendment right, or saying that they don't want to talk to the police, or saying that they want an attorney before they talk to the police because they're invoking their Miranda rights. That is the same thing as saying that is somehow probative of her state of mind of guilt. Looking for an attorney, looking for a DUI attorney, looking for any kind of attorney should not be coming in to this trial. Absolutely. So just to summarize for folks that are a little confused as to what's happening, the Commonwealth here is trying to introduce evidence of a Google search by Karen Reed at 1:27 p.m. for some DUI attorneys, or for a DUI attorney. And so they're trying to say, oh, that shows her state of mind. That shows that she has a guilty state of mind because of the fact that, she's looking for a DUI attorney. I'm sorry. No, looking for an attorney to represent you does not make you guilty. It means you understand that there is a particular issue that maybe someone might start pointing a finger at you, and maybe it's better to have someone looking over your shoulder and helping to protect you, because maybe you might just get steamrolled by the state. So I'm sorry. No. 1,000 times no. This should not come in. This is absolutely prejudicial, not probative.
Justice of guilt at that time. This statement is before she voluntarily gave an interview with law enforcement. It goes to her state of mind prior to that interview. And so for all those reasons, the Commonwealth would suggest that Google search is appropriate. And it's not a typical case where it's an invocation of counsel, where law enforcement had not engaged her, and it goes to her state of mind at that time prior to any police involvement, and further to rebut that there was any improprieties in the police investigation, or that they should have investigated anyone else.
All right. And I appreciate, Mr. Lally, you bringing this to our attention to give us time to look at it. Ms. McLaughlin, I appreciate that you provided a very strong limiting instruction proposal. I'll hear you, Ms. Gianetti.
Thank you. Your Honor, you had asked that I produce proof of the phone call from Michael Proctor 295.
Oh, I didn't say proof. No, I asked if that was coming into evidence.
Okay, well, I'd like this marked for identification for the purpose of this argument, if I could.
Sure.
Show counsel.
Yeah, Debbie Faison Cook, having an attorney is not consciousness of guilt. No, wanting an attorney is not one either.
Okay.
No freaking
So
way.
let's have it marked for ID before I hear you any further. So Madam Court Reporter needs to mark it. All right, and if I may have that. Thank you very much. Just give me a minute, Ms. Giannetti.
Lulia Descalo, welcome to Bike Club, or welcome back to Bike Club. Looks like you're at Green Apple status, so you've been in Bike Club before. Welcome back. So happy
All right,
to
so
have
this
you.
is just that a call occurred, right?
That a call was made from Michael Proctor's personal cell phone number. You can see the last 4 digits there, to my client at 1:19 p.m. on January 29th.
Ooh,
okay.
Approximately 8 minutes before she calls to investigate a potential DUI attorney.
Okay, so focus on the law.
So, okay, that's also interesting that that would be the reason that would tip her off. So if they're arguing her mental state, like even just aside from the wanting an attorney is somehow consciousness of guilt, like that kind of, I'm sorry, I'm gonna say the full word. It's bullshit. I normally try to censor myself because of YouTube gods, but like this is that level that I'm gonna use the full word. Like, no, I'm sorry. No. Wanting an attorney, wanting to look for an attorney should never, ever be considered consciousness of guilt. But just to finish up what I was saying before, Lulia Descalo, welcome back to Bike Club. So happy to have you here. Thank you so much for supporting the channel. All right.
Offer me and tell me why I should exclude this.
Of course, yes. With regard to the case,
all the reasons
Commonwealth has cited, I think the court has seen. One of them is an unpublished opinion. The other is a homicide case. They couldn't be more distinguishable from this case. With regard to the unpublished opinion, that appears to have been a gun charge where the defendant in that case did a search for a 9mm handgun on his cell phone. He did not ask for Google or search in Google for a handgun attorney. He made a specific inculpatory search that the court ruled was relevant, and it was not outweighed by the danger of unfair prejudice. In this case, we have a person being contacted by the police and then doing what a citizen has every right to do, which is to look for an attorney for representation. There's zero probative value to that.
Yes.
Other than she's presumed to be innocent and she's seeking an attorney to defend that presumption of innocence. That's it. There's zero probative value. But there is an extreme and unfair prejudice in this case. Your Honor, the limited instruction that the Commonwealth has provided asks this court to instruct the jury whether her action in doing an internet search for an attorney indicates feelings of guilt by a defendant. I can't even believe that argument.
So let's just focus on the law.
I'm trying to, Your Honor. I'm flabbergasted.
So what I'm going to do.
That flies in the face of Miranda rights. Like allowing that in flies in the face of Miranda, because you would use the same logic to say this person who is in custody by the police and is being questioned by the police is now requesting an attorney, and that we want to use that to show consciousness of guilt of this person. You cannot do that. You cannot. There's so much Supreme Court case law on that like you can't then like use the same kind of logic to be like, well, no, in this case, you know, the same sort of feeling to want to have an attorney in this overall case that like somehow that shows consciousness of guilt. That's just insane. Like the fact that this is even being entertained as an argument is just like wild to me. It is, you know, to use a word that Emily D. Baker uses a lot, the audacity. This is absolutely completely bananas and just absolutely audacious that they would go this far to try to introduce that and to say that somehow wanting an attorney when you have already been questioned by the police, you know, and given a number of statements that you know, that somehow that shows guilt that you want an attorney. Like what? I'm infuriated at this point. I'm absolutely infuriated that there's this supposition. Okay. So, but to back up just a little bit to what Yannetti said, he started off by quoting another case. And what the judge said was that, that the judge wanted to hear from case law. She keeps telling him like, okay, bring it back to case law. And so the first case that he referred to, I think, is probably one that was cited by the prosecution in their motion to try to have this entered in. And he said that, this is entirely distinguishable. What they used was an example from another case that where they had allowed a certain Google search in. And his point was, this was in that other case, there was an inculpatory search, meaning it was a search that brought up guilt. It's the opposite of exculpatory, which means that it's the kind of thing that is going to show someone's innocence. Inculpatory is going to show someone's guilt or state of mind or what have you. So, he said that there was another case where a guy did a Google search for a type of a handgun. That is not the same thing as searching for an attorney. I'm sorry. There's no universe in which those two things, searching for those two things, are anything close to one another. So he's like, that's entirely distinguishable on that side. And then I think he also mentioned that there's another case that he looked at and said that also that one is distinguishable. He hasn't gone into detail about it yet. I'm hoping that he gets into it as well. But it's like, oh my God, this is just absolutely, I'm completely livid about this whole argument right now, because this should not be a conversation. This should not even be a conversation to begin with.
Then it is, I'm going to stop you. So on the balancing act that I have to do, I find that the probative value is outweighed by the prejudicial.
Okay.
All right.
God.
So,
oh my God.
I'm not going to allow it in, Mr. Lally, in your case in chief. Now, if you feel that through this witness or through any other witness, Mr. Lally, that it then is admissible, I just ask that you come to sidebar beforehand.
Absolutely, Your Honor.
Okay. All right. Let's bring Trooper Guarino back in, please.
Oh my God. Thank God. Thank God she saw through that.
Yes, please.
And because that 100% would have been reversible error. I'm still mad that even was a conversation. That shouldn't have been.
Trooper, if you have a bad back and you need to stand, just stand at any time.
Thank you, Your Honor.
Okay.
Okay, so I think the jury's going to be coming in now, so we'll fast forward. I mean, I almost went like apoplectic over that. Okay, come on. All right. Oh, now it's cross-examination. Okay.
Mr. Lally, you left your material here.
Yeah, get your junk out of here, Lally. I'm kidding, obviously.
Trooper Guarino, you've testified that you disagree in many respects with the findings of the defense expert, Rick Green, which he outlined in his affidavit submitted in connection with this case, correct?
Yes, that's correct.
I'd like to ask you some questions about your training and education and your qualifications in the area of computer forensics. You graduated from Westfield State University in 2003.
Yes, that's correct.
You made
Really quick, let's just to make sure that everybody is on the same page. Dan Luch, thank you so much for the super chat. What did the judge say? I'm also flabbergasted. So she said, okay, so what she said is any kind of evidence that comes in, there has to be a balancing test, right? It's how prejudicial is it? How probative is it? If it is more probative, meaning it's more likely to help the jury in the determinations that they need to make. If it's more probative than prejudicial, it can come in. But if it's more prejudicial than it is probative, meaning it's going to, if it's more prejudicial than it is probative, it's going to lead the jury astray. It's going to confuse them. It's going to make them think about the wrong things in the case. They might make a decision based on something that they don't fully understand, that they can't really set aside. Like it can be emotional things, all kinds of things. So if it's more prejudicial than probative, it's more outrageous, kind of spicy outrageous than it is helpful to what they actually need in order to make a determination in the case, then it doesn't come in. So she said in this case, it's more prejudicial than it is probative, and therefore not coming in. So that Google search is not coming in at all, which is absolutely 1,000,000% the right call. All right.
Majored in criminal justice and mass communications, correct?
Yes, I double majored.
Right. You chose not to major in computer science, correct?
Yes, that's correct.
2 years after graduating, you became a patrolman in Norwood, correct?
Yes, that's right.
The town of Norwood is right next to Canton, is it not?
Yes, it is.
You stayed as a patrolman in Norwood for 10 years with the Norwood Police Department, correct?
Minus a stint in the National Guard, but yes.
You then became a Massachusetts state trooper in 2015,
Yes, I did.
and you spent 4 years in the patrol division of the Mass State Police, correct?
Yes, I did.
And that was until 2019?
Correct.
And 2019 was the first time that you took a forensic computer course. Would you agree with that?
No, that's not true.
Would you agree with me that since then, your training has mainly consisted of online courses and webinars?
That is also not true.
Okay, well, you list, with regard to your training, some in-person trainings, sir, but you list 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, actually, over 20 online courses, do you not?
Yes, that was during COVID.
Yeah. Well, 2019 was not during COVID, was it?
2020 was
All right.
when I took most of them.
I got you, but you say 2019 to 2020 in terms of your online courses and webinars, correct?
There's quite a few, yes.
All right. And with regard to some of the courses that you were taking during that time period, would you agree with me that one of them was Introduction to Computer Networks?
So that course was through the NW3C.
I didn't ask you where it was from. I asked you whether one of the courses that you took was called Introduction to Computer Networks.
That's correct.
And another course that you took was Introduction to Cell Phone Investigations, correct?
Yes.
So you guys can probably tell what he's doing here, what Yannetti is doing here. And this right here is he's going through the educational side of this trooper Guarino, basically showing like, okay, now it looks like you've got a really robust file of education here, but like, let's take a look at the courses that you actually took when you were doing these online courses. This is all introductory stuff, all super basic stuff. None of this should indicate anything about someone being an expert as a result of these courses, right? You don't become an expert in computer networks when you just take an introduction to computer networks class. But maybe some of these courses will become more advanced at a certain later point in time. Maybe. But at this point, this is what you do on cross-examination is you point out the weaknesses in this person's testimony and with an expert in their background.
Introduction to previewing, correct?
Yes.
You hold no degrees in the field of computer forensics, do you?
I hold certifications.
You hold no degrees in the field of computer forensics or computer science, correct?
Like college degree?
Correct.
Yeah, correct.
You have no publications in the field of computer forensics, do you?
No, not yet.
And you've never taught a course in computer forensics, have you?
No.
All right. Well, as a Norwood police officer for 10 years and a Massachusetts state trooper for 9 years, you would agree that you've written a lot of police reports over the years, have you not?
Yeah, you could say that.
Prior to becoming a Norwood police officer back in 2005, you attended a police academy, right?
Yes, I did.
And at the academy, one area of focus was the proper way to write a police report, was it not?
Amongst others.
You were taught that it's important to write police reports close in time to the events in question while they're still freshest in your memory, correct?
That's not necessarily the case.
Okay, so is it your testimony before this jury that it's preferable to wait months before you submit a police report on something that happened months ago, sir?
Well, it depends on the data that I'm using. If I can't get into a phone, then yeah, I have to wait months.
Okay. But once the information is received that you need to write a police report, would you agree with me that it's important to record it in a report as soon as you can?
No, I stand by my previous statement that as soon as the data is available that I can do it, I will. And if, things come up, then, I do it when it's able.
Sorry, Karen's face right there was I feel like what my face was. I don't think I was doing the same thing, but that was how I was feeling, right?
So I think you just answered my question. You said as soon as the data is available and you've completed your investigation.
I never said I completed. I said if the data is available.
Well, then let's say you've completed your investigation, sir. Are you going to argue with me that it's preferable not to wait to record that data in a report?
Objection.
Ask it differently, Ms. Giannetti.
He's arguing a little too much for.
You were also taught that it's important to include all the important details in your police report, correct?
Again, it depends on the report I'm writing.
I understand that sometimes there probably are factors that can get in the way of someone being able to write a contemporaneous report, but I don't know. I would think that there would be something that could be done to take contemporaneous notes. You can show, how things are updating with timestamps. I don't know. There are ways of doing that without having to I don't know. It seems to me that his responses are a little too wiggly.
Okay, so in other words, there are times when you're writing a police report when you intentionally leave out important details, Trooper. Is that your testimony before this jury?
Objection.
I'll allow that question. Is that what you do, Trooper?
No, ma'am.
Okay.
Your Honor.
So you would agree with me, going back to my question, that it is important to include all the important details in your report, is it not?
Again, it depends on the report that I'm writing. There's some data that goes in, there's some that doesn't. I can't have everything in. Again, for phone, I'm speaking to technically phone reports or cell phones, computers. I can't include everything. That's why we have the program that if I need to add something via Cellbrite or Axiom, I can create a report through that. If I did a handwritten report for everything, they'd be thousands of pages for the amount of data in these devices.
Fair enough. But that's not what Reacher says.
In an investigation, details matter. Details matter. Keep telling you, Finley.
I know details matter. Let's go.
Sorry, I couldn't help myself. That one I actually haven't used during live streams. I used it during one of my early recaps. But fair point. Fair point. Details do in fact matter. And to the credit of the witness here, you can't put in absolutely everything. That doesn't make any sense. But the details that are material, you want to make sure are included in the investigation. Hi. Okay.
One purpose of writing a police report is to share information with your fellow investigators, is it not?
I suppose so.
Another purpose of writing a police report is to be fair to the people that you're investigating by explaining as best you can what happened, correct?
I don't understand that question, Denham.
Yeah, he doesn't understand the concept of fairness to the people that are being investigated. That's you're definitely going to have to try to ask that in a different kind of way, because that might be a concept that is not understood by the Massachusetts State Police based on what we've heard so far in this trial.
Okay. The fact is you did write some early police reports in this case dated February 4th, 2022, just 6 days after John O'Keefe was found mortally wounded on Brian Albert's front lawn, correct?
That is correct.
When you wrote those police reports, you knew this was a homicide investigation, correct?
I was told that it was believed to be yes.
So that underscored the importance of being accurate and truthful, correct? Especially in a homicide investigation?
I write my reports, no matter what the investigation is, the same exact way.
And the purpose of one of your February 4th, 2022 reports was to explain how you came into possession of John O'Keefe's cell phone and to note the extraction that you did on the phone. Do you recall that report?
Yes, I do.
And before writing that particular report, you spoke with Trooper Michael Proctor, did you not?
I received the phone from him, but
I'm sorry?
I received the phone from him originally, yes.
Okay. And when you received the phone, the two of you did not remain mute, right? The two of you chatted?
I don't remember the exact conversation.
But there was a conversation, correct?
I'm sure there was.
And you recorded what Michael Proctor told you about that cell phone in your February 4th, 2022 report, did you not?
No, I didn't.
Michael Proctor told you that on Saturday, January 29th of 2022, he and Sergeant Buchanan had responded to 34 Fairview Road in Canton. Did he not?
Objection.
I'll allow that.
No, he didn't.
Well, you wrote in your very first sentence in that report the following, quote, on Saturday, January 29th,
Objection.
2022, Trooper Michael Proctor and Sergeant Yuri Buchanan of the Norfolk County District Attorney's Office responded to the unattended death of John O'Keefe at 34 Fairview Road in Canton. Those were your words, were they not?
All right, so the objection sustained, you can ask it differently.
Did Michael Proctor tell you that he had received or retrieved John O'Keefe's cell phone from 34 Fairview Road in Canton?
Objection.
I'm going to allow that.
No, I didn't know where it was retrieved from.
You didn't know where it was retrieved from?
Correct.
All right. But you did include in your report that while Proctor and Buchanan were on scene, they retrieved the cell phone of John O'Keefe, correct?
At some point during the day, they did. I don't know where from. So there's multiple.
Yeah, I'm asking about your report, Trooper. You know I'm questioning you about your report.
No, I understand. I'm explaining. I don't know what scene
You don't get to
it's
explain, sir,
Oh.
most respectfully, until Mr. Lally questions you.
Objection, Your
Okay,
Honor.
so no comments. I think to speed things along, do you have your report with you?
I do, Your Honor.
I think it'll make it easier, Ms.
Can you read the
Giannetti.
first two lines of that?
Let him grab it.
He's getting a little bit testy. He's getting a little bit testy with Giannetti's questioning, and we'll see. He's definitely feeling the pressure. That's for sure.
Go.
Can you read the first two lines to the jury, please?
Yep. On Saturday, January 29th, 2022, Trooper Michael Proctor and Sergeant Yuri Buchanan of the Norfolk District Attorney's Office responded to the unattended death of John O'Keefe at 34 Fairview Road in Canton. Through his investigation was found O'Keefe was a victim of a motor vehicle homicide. While on scene, Trooper Proctor secured O'Keefe's phone and brought it to the Norfolk DA's office for forensic analysis.
Okay. So you'd agree with me that you included that clause, while on scene, they secured his phone, did you not?
I did write that.
Okay. And that was back on February 4th of 2022, correct?
Yes, it was.
Within 6 days of John O'Keefe being found mortally wounded on Albert's lawn, correct?
Yes, sir.
And at that time, you knew that the crime scene was 34 Fairview Road, correct?
No.
Yet you put in your report while on scene, did you not?
Yes, I don't know what scene they recovered from. I know they went multiple places on the 29th. They didn't get back to me till 7:30 that night almost, when I first got the phone.
Well, you'd agree with me that the Canton Police Department wasn't the crime scene, correct?
I never said crime scene in my report. I wrote scene.
Okay. Well, Canton Police Department was not the scene of any crime, was it?
I don't know. I don't believe so.
You don't know.
What do you mean you don't know? Is it because you know of a police cover up? Is that what you're saying? I'm not saying that. I'm personally not saying that. I still don't know about what I feel about the framing conspiracy, but it's just like, sir, why would you say that? Why would you say you don't know if Canton PD is the scene of the crime? Come on. Like, I think he's trying to be stubborn to stick to a point, but it's like sometimes being that stubborn on cross-examination when you're getting questions that are intended to show a little bit of ridiculousness of your position, it doesn't make sense to stick to it. We saw that with God, what was his name? It was like so many years ago now. The boyfriend of one of the girls in the family. She was either a McCabe or she wasn't Caitlin Albert, was she? It wasn't Allison McCabe. I guess it was Caitlin Albert's boyfriend. I guess now fiance or whatever. That was like, well, I don't know time. But yeah, like sometimes being a little bit too stubborn with what you're saying on the stand can end up looking foolish.
If the Canton Police Department was the scene of a crime.
I don't think it was.
You don't think it was? Okay.
Oh,
Now,
Tristan. Yeah, that's right. That's who it was. Tristan.
in that report, you were trying to establish the chain of custody of that phone, right? Because you described where it was found, where it was taken, and who had possession of it, correct?
I said it never said where it was taken. I said the phone was recovered on scene by Trooper Proctor. Again, I don't know where it was recovered from. I did find out later it was at Canton PD.
Well, hold on a second. We're focusing on your report.
I know, I'm reading it.
As opposed to details you want to fill in now, okay?
Okay.
With regard to, you just testified that you never said where it was taken.
Is it about to object?
Previously, you said it was taken to you, was it not?
No, I said recovered from, like the scene location.
Did Trooper Proctor take the phone to you and
Yes.
hand it to you?
Yes, he did.
Okay, so it was taken to you, correct?
That is correct.
All right. So you described in your report where it was found because you said while on scene, correct?
Correct.
And where it was taken to you, correct?
Yes, sir.
And who had possession of it, which was initially Trooper Proctor in terms of your observations, and then you, correct?
That is who brought me the phone to the DA's office, yes.
And you would agree with me that chain of custody of a piece of evidence is an important detail in any criminal investigation, isn't it?
Yes.
Would you agree with me that someone reading your report or listening to it as the jury listened today would understand you to be saying that Michael Proctor seized John O'Keefe's cell phone at 34 Road in Canton?
Objection.
Sustained.
All right. I'd like to ask you some questions about the extraction that you discuss in that same February 4th, 2022 report, the very same report. In that report, after you name the tools that you use to extract data from the phone, you indicated that a copy of that cell phone extraction was placed on a state police server, or was it a DA's office server?
DA's office server.
Okay, on a server so that it could be accessed there, correct?
That is correct.
But that extraction you placed on the server did not include all the potential data on John O'Keefe's phone, did it?
How do you mean?
Well, didn't you indicate in your report that the extraction was not inclusive of all potential data contained within the device?
No, that's not true.
Well, the extraction that you did contained communications, iOS messages, phone calls, social media communications between John O'Keefe and Karen Reed, correct?
Yes, that's correct.
And it contained communications between John O'Keefe and Jennifer McCabe?
Yes, that's true.
It contained communications between John O'Keefe and Kerry Roberts?
I can't recall.
All right. But it did not include any communications between John O'Keefe and Julie Albert, did it?
Again, I can't recall.
And again, I'm talking about that initial extraction. That initial one didn't include any communications between John O'Keefe and Chris Albert, did it?
I only created one extraction of John O'Keefe's phone.
All right. That extraction report also did not include any location data, did it?
No, it did.
You didn't note any location data in that initial report, did you?
In the February 4th report?
Correct.
I didn't go through the data at that point.
All right.
This is just my extraction report saying that I got the phone, it was extracted and placed onto the server. And then I wrote, this report is not inclusive of all potential evidence, potential data contained within this evidence.
When was the first time that you reported on location data in this case?
I don't remember.
Wasn't until April of 2023, correct?
Oh, there was a reason for that.
Well, I didn't ask you if there was a reason for it, sir. You understood my question, didn't you?
That's correct. My first report regarding was in January.
We're talking about John O'Keefe's phone now here.
Yeah.
You did not report on the location data on John O'Keefe's phone until April of 2023, correct?
I didn't look at the extraction initially.
And you also did not report on any Apple Health data until the spring of 2023, correct?
Again, I didn't look at the phone extraction. Trooper Proctor would have looked at it. I would have loaded it and given it to him.
Okay, so Trooper Proctor had access to the phone first, and then you took care of it, correct?
He had access to the extraction that I would load onto Cellbrite for him to look at, where you can't change the data. That is correct.
Okay. And you would agree with me that you didn't address John O'Keefe's health or location data in any formal report until that April 23 report, correct?
That is correct. I never went through it.
Right, and you submitted your report in April of 2023 after you became aware of an affidavit filed by the defense expert, Rick Green, in which Mr. Green extracted and analyzed John O'Keefe's location data and his movements according to Apple Health data. Isn't that correct?
Yes, that is correct.
Before Rick Green submitted that affidavit, no member of the state police homicide investigation team, including you, had ever looked at or at least reported on the location data for anyone present at 34 Fairview, correct?
For the devices that we had, sir?
For John O'Keefe's device, for Jennifer McCabe's device, etc.
I can't speak to that. I don't know.
All right, but you didn't, correct?
Again, I didn't look at the extractions until later.
Right. So you hadn't looked at John O'Keefe's location data in particular prior to Richard Green pointing out the location data in his affidavit, correct?
Again, I don't know. I wasn't asked to look for that data when I did look at it.
On it, correct?
Yes, there's no report until then.
Right. Same with Jennifer McCabe's location data. You didn't report on that either, correct?
I didn't look at Jen McCabe's phone.
All right. You didn't report on Brian Alberts or Colin Alberts or Brian Higgins' location data. Would you agree with that?
I didn't have any of their phone extractions to get that data.
Of course not.
So I wouldn't be able to anyways.
But when you finally did check the location data, I want to ask you about your testimony on direct examination that you believe that at a certain point with regard to John O'Keefe's phone, the accuracy of the GPS points was within 3 feet. Do you remember that testimony?
Yes, sir.
All right. Can you show me where in any of your reports you specify that the GPS points are accurate within 3 feet?
I don't know. I don't have it in front of me. In my reports or the action report?
Yeah, no. Any reports that you have in front of you or any that you reviewed? Where is that?
I think he's trying to say literally anywhere. Show me anywhere. That's what he is saying here. Like, sir, produce this. Not out of thin air, please. That's what he's definitely suggesting here with that question.
What do you, that I wrote that?
Is it in writing anywhere, sir?
Yes, I wrote in my report that we believe we were within 3 feet of the latitude and longitude points that were mapped in Sartopo when we went to scene. That is the second report that I did, sir.
The May of 2023 report?
May 9th, 2023.
All right. Now, let me just have a moment.
Yep. It's page. It'll be page 4 or 5. It should be in the top there. Paragraph 9. Can read it if you'd like.
Hang on. Would you agree with me in paragraph 9? There is nothing that mentions that the accuracy is within 3 feet?
From the program?
No, I'm asking you about a report that you authored, that you just mentioned to this jury.
It's in paragraph
Now,
paragraph 12. I'm sorry. It says Trooper Proctor and I began to measure.
I'm sorry.
Oh, sorry. Sorry, I'm sorry. I wrote Trooper Proctor and I began measuring the approximate
I'm
location.
not asking you to read it.
Oh, okay.
You're mentioning paragraph 12 and
Yes, sir.
you're talking about one particular spot in that, correct?
Yes, that is the spot that we
All right.
pointed on our
Now, with
location.
regard to John O'Keefe's phone, would you agree with me that it's important to properly handle and secure a cell phone that is seized in connection with a homicide investigation?
Yes.
Was it important in this investigation to properly handle and secure John O'Keefe's cell phone since he was the homicide victim?
I mean, it was. We locked it in a secure evidence lab.
All right. Well, you testified that the first time you reported on in your investigation or your evaluation of the location data, that was in your April 24th, 2023 report, correct?
Yes, sir.
And in that report, you revealed that you looked at his location data using Axiom software, correct?
Yes, sir.
And Axiom is a competitor of Celebrate?
Did you say that? Yeah,
And Axiom is relied on by law enforcement across the country?
I believe so.
And you relied on it here in terms of this issue of the location data, did you not?
I used multiple programs, but yes, I used Axiom as well.
And regarding the location data that you examined with regard to John O'Keefe's phone, you noticed, or you noted, I should say, that after a period of no speed having been registered for a period of time, John O'Keefe's cell phone started registering movement at 6:04 or 6:15 a.m.?
6:15 a.m.
6:15 a.m., and that's actually 6:15 and 36 seconds, correct?
I don't have it in front of me, but I believe that's correct.
Sounds right?
Yeah.
And at that point, his phone registered a speed of 0.0484 meters per second?
Just want to confirm.
Sure.
Is that the second report or the first report? I'm sorry. There it is. Yep. 0.0484.
0.0484 meters per second?
Yes.
And that's at 6:15 and 36 seconds?
Yes, it is.
All right. So now, as you were examining that data, sir, you certainly knew from this investigation by that point that when the phone was moving, according to that data, at 6:15 and 36 seconds on January 29th of 2022, John O'Keefe had already been found mortally wounded and incapacitated, correct?
From the voicemail message, that's how I was able to. I don't know the exact time frames that he was found and transported, but I know 6:08 from Miss Reed's voicemail that the 911 call is made, and
Okay,
they're on scene.
I think we're talking over each other here, because what I'm asking is, you knew that by 6:15 and 30 seconds in the morning on January 29th, John O'Keefe had already been incapacitated and mortally wounded. That was my question.
Oh, yes, sorry.
Okay.
I misunderstood.
So you knew from your investigation that meant it could not have been John O'Keefe moving with his phone at 6:15 and 36 seconds, correct?
That is correct.
It had to be somebody else, correct?
Yes.
Would you agree with me that once investigators took possession of John O'Keefe's phone, any movement of his phone after that would not help in your homicide investigation, would it?
I don't understand.
So in other words, John O'Keefe's been incapacitated.
Yes.
Somebody from law enforcement seizes his phone. Would it help your investigation or the investigation of the Norfolk Detectives Unit to track and record location data on that phone after 6:15 a.m.?
Well, it's there. I did look at it. It goes to Canton PD and then later comes to the office.
I asked. I didn't ask if it's there. I know it's there. I'm asking you, does that help you in your investigation of a potential, or of a homicide, to track the phone and have that location data recorded on the phone after John O'Keefe could not have been the one moving with it?
No, not necessarily.
In fact, if the phone is manipulated in some way after investigators take possession of it, that could potentially harm an investigation, couldn't it?
Objection.
Sustained.
Well, to preserve the integrity of the data on the phone as it existed before the police took custody of the phone, there is a way to stop the phone from recording location data, again, after the police take custody of the phone, isn't there?
Yes, if you can, place it into airplane mode.
Yes, yeah, you mentioned on direct examination that it could be accomplished by putting the phone into airplane mode, correct?
That is correct, sir.
But when that phone was seized, no investigator put the plane into airplane mode that early morning because you know that location data was found on that phone, correct?
I don't know when it was placed in airplane mode.
But you know it wasn't by 6:15 a.m., correct?
That is correct.
All right. And there's also another way to prevent any signal from entering or exiting the phone. You'd agree with that?
Yes, there is.
During your direct examination, you mentioned the concept of a Faraday bag.
That is correct, sir.
A Faraday bag has special fabric that blocks electromagnetic signals entirely, does it not?
Yes, sir.
So putting the phone into a Faraday bag would be another way to stop the phone from recording location data while the phone's in police custody, correct?
Yes, sir.
And you'd agree with me that during that early morning hours, as of 6:15 a.m. and thereafter, no investigator in this case put that phone into a Faraday bag on January 29th, correct?
Not to my knowledge.
In fact, after John O'Keefe's cell phone started registering movement at 6:15 and 36 seconds in the morning on January 29th, it continued to record location data the rest of the morning until 11:56 and 1 second a.m. on January 29th, correct?
I don't know the exact end time, but I know it does have GPS data points throughout the day.
Mr. W, thanks for the super chat. This team does a good job making witnesses fight. Agreed.
So you would agree with me that for several hours after the police had the phone, it was not put in a Faraday bag and it was not put into airplane mode, correct?
That is correct.
All right. Now, with regard to the voicemails that you've previously testified to and that the jury has heard and they've been introduced into evidence, you had testified on direct examination that Karen Reed's phone connected to the Wi-Fi at 1 Meadows Ave at approximately 12:36 in the morning.
Yes, sir.
So you can testify based on that by 12:36 in the morning, Karen Reed was not at 34 Fairview, correct?
That's correct.
And that was the first of those voicemails that you testified to, correct? That was the I hate you voicemail?
Yes, that's 12:37, correct.
Okay. And that voicemail and every other voicemail that the jury heard was left after Karen had left 34 Fairview, correct?
Yes, sir.
And except for the one at, after 6 in the morning, the 4-minute one when she went back, we heard that one. But all the other ones were apparently left when she was at 1 Meadows, correct?
I can't speak to where she was, but
she wasn't at 34 Fairview.
yes, that's correct. She wasn't at 34.
And you would agree with me, based on those voicemails and what you know about them and what we've just discussed, that no one at 34 Fairview, including Jennifer McCabe, could have witnessed Karen Reed outside that residence at 12:45 a.m., correct?
No, I don't believe so.
So you agree with me? No one could have, including Jennifer McCabe, could have seen her at 12:45 at 34 Fairview?
As I said, she auto connects to the Wi-Fi at 12:36, so no, she wouldn't have been there.
Okay.
All right. Now,
for a second, I thought he was going to say like, no, I think that's possible. Okay. I'm glad he clarified that.
we've talked about the findings of, or the fact that you reviewed the findings of Rick Green by reading the affidavit that he submitted, correct?
Yes, sir.
And you learned in that affidavit that Rick Green was able to track not only when John O'Keefe arrived at 34 Fairview, but also the route that he and Ms. Reed took to get there on January 29th, correct?
I don't recall his report fully, but
you learned that he was able to accomplish that by examining the data from the app Waze that you spoke of, correct?
yes, I did find that myself.
All right. And Waze is spelled W-A-Z-E, correct?
Yes.
All right. And you've previously testified it's a commonly used app for driving directions and navigation?
Yes, sir.
And regarding your analysis of the phone, you learned that there was Apple Health data from John O'Keefe's phone on January 29th of 2022, correct?
That is correct.
And Apple Health data can reveal a number of steps that a person has taken during a given time period, as well as whether that person is going up or downstairs, correct?
Yes.
And on John O'Keefe's phone, you learned that there was Apple Health data that tracked his steps from the time he's seen on surveillance video leaving the Waterfall Bar and Grill and moving forward after that, correct?
I don't know anything about the Waterfall Bar video. I just have the timestamp from the phone showing it at around 12:12 at the waterfall.
All right, and it actually was between 12:11 and 9 seconds, and then the ending period of that first time period was 12:21 and 5 seconds. And then you.
Oh yes, from the health. Thank you. Yes, yeah.
Okay, from the Apple Health, and the data showed that he took a total of 170 steps between that time period. Correct?
That's what the phone registered. Yes.
All right, and regarding those 170 steps, isn't it true that this data from Apple Health signifies that 170 steps took place at some point during that 10-minute approximate time period?
No.
So is it your understanding that those 170 steps all took place at 12:11?
No. Again, like I said, the phone is a high-tech pedometer. It doesn't mean that steps were taken. It means the phone was manipulated in a way that it believed it was moving and taking steps.
Oh, I see your objection.
Yeah.
Okay, so
sorry.
Yeah, let's assume there were steps for the purpose of this discussion.
Yeah.
Okay, and they could have been steps, correct?
They could have been, yes,
Okay,
but
all right. So let's assume.
no way to prove.
Let's assume that for now.
Okay.
Assuming there were 170 steps taken, that could have meant that John O'Keefe took 170 steps beginning at 12:11 within that time period, correct?
It's saying again, the time frame that it gave me is 12:11 to 12:21.
Right. Yeah. So in other words, if he could have started walking at 12:11, correct?
Yes.
All right. But he also could have taken that 170 steps closer in time to 12:21, correct?
Well, at that point, he's in the car.
I'm not asking about where he was.
Could not have been. No.
I'm just asking about with what the data shows.
And I would say no.
If it shows 170 steps between 12:11 and 12:21, then strictly based on the data, you don't know where those 170 steps took place within that 10 minutes, correct?
To a degree, yes.
Okay. And it's possible it could have been toward the beginning, toward the end, or maybe fairly evenly spaced, right? You just know that there were 170 steps that were taken in that 10-minute time frame, correct?
Again, that's assuming that they are steps.
Right. And again, I'm asking you from the data itself.
Again, the phone says it's steps, doesn't mean they are.
All right. Well, the Apple Health data also showed a total of 80 steps between 12:21 and 12:24.
Correct.
As part of your investigation of this case, were you aware that there was a 12:23 text message from Ryan Nagel to Julie Nagel in which Ryan texted his sister Julie he had arrived at 34 Fairview?
Objection.
Sustained, you can ask it differently.
In any case, you would agree with me that 12:23 is between 12:21 and 12:24, correct?
That is correct.
And that is the 12:21 to 12:24 time frame where the Apple Health data showed that the user of John O'Keefe's phone took 80 steps, correct?
Yes.
All right. Now, John O'Keefe's Apple Health data also showed that he climbed up or down 3 flights of stairs between 12:21 and 12:24, correct?
Yes.
And that's the same period in which the data reflects 80 steps, correct?
It's off by about 12 seconds. It's 12:22, 22. That's right, 12:24 and 22 seconds was the ending for the stamps, but 12:24 and 37 seconds.
Okay, but approximately.
Yeah. Approximately, yes.
All right. And regarding going up and down those 3 floors, Apple does not provide data precise enough to determine when within that range the 3 floors were transversed, correct?
No. There was a second point at 12:22 and 14 seconds that had specifically on stairs.
Okay. And you would agree with me that, and again, assuming that they were stairs as Apple Health data reflects, those stairs could have been ascended or descended toward the beginning, toward the end, or throughout that 3-minute time period, correct?
In this case, no, because there's a set point that's in the Cellbrite report that shows it's 12:22 and 14 seconds.
All right. Finally, his Apple Health data also showed a total of 36 steps between 12:31:56 and 12:32:16, correct?
Yes, that is correct.
All right. So I would like to direct your attention to your May 9th, 2023 report, which was the second report that you wrote that we've already referenced.
Yes, sir.
Specifically paragraph 15.
Okay.
you wrote that O'Keefe's health data in Celebrite shows him ascending, descending 3 flights of stairs at 12:22 and 14 seconds. Did I read that accurately?
Yes, sir.
And the native locations in Celebrite and the cached locations in Axiom both show O'Keefe's phone location by the intersection of Oakdale Road and Pinecone Road, which is in front of 36 Oakdale, and which is approximately a little over a half mile from 34 Fairview. Did I read that essentially correct?
Yes, sir.
All right. Do you stand by the statement that he ascended and descended 3 flights of stairs precisely at 12:22 and 14 seconds?
I'm going by what Celebrite has given me from that time point, and that's what I used.
Isn't it true that what the Apple Health data actually state is that John O'Keefe's phone went up and down 3 flights of stairs sometime within the time period that began at 12:22:14 and ended at 12:24:37?
I can't speak to it. I don't know. This is what, again, I'm looking at the report. This is what the information that is parsed out of the phone is giving me.
Right. I'm just asking about the data itself. It gives you that time period and tells you 3 flights of stairs, correct?
Yes, that is correct.
All right. Assuming that those 3 flights of stairs were ascended or descended closer in time to 12:22:14, which was within that time period, that would still give him time to arrive at 34 Fairview within a couple minutes later, would it not?
I'm sorry, the time?
Yeah, so we have a time period that you've agreed with, which is 12:24:14, ending at 12:24:37, right? A little over a couple of minutes, like 2 minutes and 23 seconds?
Yeah, about that.
All right. So the 3 flights of stairs, again, just according to the data, could have been ascended or descended at the start of that time period, correct?
No. I'm confused what you're trying to say. So you're saying that he's at the house already at 12:22?
I'm not asking about the house. I'm asking about the data.
No, I know, but I'm asking about when you're saying he arrives in that data range.
No, I'm
confused.
I'm strictly asking you just to look at the data.
Yeah.
And you agree with me, whenever there's a time period and Apple Health returns either steps or stairs, you can't pinpoint just from the data when they occurred within that time period, correct?
Objection. Your Honor, maybe helpful if counsel could refer to which data he's talking about and not just keep saying. All I'm hearing is data.
I thought that was
Do you know
clear.
which data Ms. Giannetti's referring to specifically?
I'm slightly confused. I know you said that time frame that I wrote in my report for that 12:21 to 12:24. And then, as I stated before, Celebrate shows a specific time point of 12:22 and 14 seconds when the stairs are ascended, descended. So that's why I'm confused.
But, we're going to get to that, but
Okay.
I'm not asking you about that. I'm asking you about the fact that there's a time period and you can't place where within that time period, just based on that data itself.
Yeah, that's what's recorded and shown to me. So again, that's what it's shown. I can't say otherwise.
Your conclusion was that John O'Keefe could not have been at 34 Fairview Road at 12:22 and 14 seconds because Waze put him on Oakdale Road about a half mile away, correct?
12, yes, correct.
All right. And that caused you to disregard the Apple Health data or to attribute it not to steps or to stairs because he was a half mile away between that 12:22 and 12:24 time period, correct?
Yes, I attribute it to movement.
All right.
I see what the defense is going to do here because he referred to that text message from Ryan to Julie Nagel that he was there, he was at the house, and then there's a testimony from Ryan, from Julie, from all of these people saying, yes, we saw this SUV there at that time. So if Ryan's testimony was, I saw that black SUV there at 34 Fairview Road when I was there, and there's a text message timestamped for 12:22 a.m. saying, I am here. And he didn't testify that the SUV got there after him, meaning the SUV got there at the same time as him. In fact, he did say that he saw the SUV that kind of pulled up at the same time. So that throws into question, does the jury believe this Waze data point that John O'Keefe was a couple streets away at 12:22 a.m.? Or does the jury believe the timestamp on the text message and the testimony from Ryan and Julie and all of these people saying that they saw this SUV there, and Ryan and the others in the truck with him, in the pickup truck with him, saying we arrived at the same time. At the very least, there's an ambiguity. And as I've said before, muddy middle goes to the defense. If there's any kind of a question into which data might be accurate, how can you say which one to rely on? Burden of proof is on the prosecution.
So I want you to assume for a moment, Trooper, that John O'Keefe's phone location actually showed him on Oakdale Road 3 minutes earlier at 12:19 a.m. Okay, if you have that in mind?
You okay?
All right. With that assumption, would you agree with me that the Apple Health data about him taking 80 steps and climbing up or down 3 floors at 34 Fairview Road would make more sense?
Objection.
Sustained.
May we approach, Your Honor?
Sure.
Okay. We're going to fast forward. Oops. Not pause.
That apps on an iPhone. Sir, are you aware that apps on an iPhone may pull data from 3 different clocks when they're timestamping location data?
You mean like Mac absolute time or Apple
I'm
Coca-Cola
asking
time?
you. Are you aware?
Multiple timestamps that are in an iPhone, correct?
That's not my question. My question was, are you aware that an app on an iPhone may pull data by choosing from 3 different clocks when it timestamps location data?
Yes.
What are those 3 separate clocks?
Depends on the program. It could be the Mac absolute time. It could be the Unix epoch time. And sorry, there's like 2 others. I don't remember them all off the top of my head.
With regard to John O'Keefe's actual iPhone, did you research what clocks were available for apps to pull data from?
No, I didn't.
Uh-oh. Danger.
Are you aware that those 3 clocks can vary in time?
Yes.
Uh-oh.
Sometimes for a matter of seconds.
What do you mean? So
In other words, the 3 clocks could be seconds apart, correct?
I would have to see the data.
All right. And you would agree with me that sometimes the clocks could be off by 3 minutes, correct?
No, again, I would have to see the data.
May I approach?
Yes.
Maybe that's why it's important for you to research that kind of thing. If you are the expert, and you should know, and timestamps are very, very, very crucial in this case, as a matter of seconds or minutes can make a difference. Ruh-roh, Shaggy.
Mr. Lally, did you get a chance to look at that?
Let me guess. Someone else did look into it. Someone else that may be an expert for the defense maybe did look into it and shows that Waze is off by 3 minutes or more. Sorry, I'm going to fast forward.
Ask you to review it.
Okay.
Okay. Trooper, I'm going to place this before you and ask you to review it, directing your attention specifically to what is marked process 3434.
Okay. Okay.
Do you see the process 3434 highlighted in blue on what I've placed before you?
Yes, sir.
And with regard to the right side of that exhibit, do you also see process 3434 with more information on the right side?
Yes.
And do you see the 3 different clocks that are listed on that printout?
I do.
What are those 3 different clocks?
Sorry, it's a bit blurry. Monotonic date time, baseband date time, and then display date time.
And looking at that And by the way, do you recognize that as being information that was available from John O'Keefe's phone from the extraction?
Yes.
I would offer that as an exhibit, Your Honor.
Any objection, Mr. Lally?
No, Your Honor.
Is Yannetti about to tell us that this is something that could have been looked up just by like going into John O'Keefe's phone and like into the like general or settings or something like that, that they can look this up very, very quickly? Because if that's the case, then that's going to make him look really, really stupid. Like if that's something that has to be really dug into and you need like some really in-depth analysis to figure out what's being used on this particular phone, then that's one thing. But if it was like readily available and like any expert should know this before testifying to, timestamps and things like that are being used by the app, that's going to look bad for the prosecution.
What are we going to call that, Mr. Yannetti?
We're going to call that a mic drop, most likely.
It could be called, a printout regarding 3434.
Yeah.
Or printout from John O'Keefe's phone.
Okay.
Thank you.
Thank you. Now you have Exhibit 640 in front of you, sir. Looking at 640, is it clear to you that those three clocks were not in sync regarding that one process number?
Yes.
In fact, the monotonic clock regarding this particular Waze artifact from John O'Keefe's phone says 2:22 a.m., while the baseband and display clocks have timestamps 3 minutes earlier, correct?
Oh, no.
Yes.
So if there's a 3-minute difference between the clocks, well, strike that. Do you know, with regard to that 2:22 a.m. location data on Waze, do you know which clock Waze was using for that? Or the iPhone was using with Waze?
I don't. Didn't look through Axiom. I was using Cellbrite for that.
Okay.
See, I didn't actually look through this stuff before I decided to make a bunch of conclusions as to date times and timestamps. And, it didn't occur to me to actually look to see which clock this particular app was using for this particular phone to see just how accurate these date times actually are for this particular app before I decided to rely upon them. I just decided to go with it, Your Honor. By the way, there are over 1,600 people in the chat right now. Very happy to see all of you guys here. If you have not done so already and you are enjoying the content, please do like the video. It really, really, really does help us to push the video and the channel out to the YouTube algorithm. I like to say the algorithm god. Sometimes people have some objection to that. I don't mean that quite literally. But you know what I mean, out to the algorithm to push this Boston Tea Party, as I like to call it, out to more people so that they can join us for it. And if you are absolutely enjoying this and you want to support the channel, because of all, it does take a lot of resources to put all of this together between the live streams and the recaps and everything. I can't do all of it myself. I've tried before. It doesn't work, but it helps to have resources so that I can do the coverage in the way that I really want to, that is best for everybody. So if you are really, really wanting to support it, there is a way. And if you are able to, of course, no shade if you can't, but if you are able to and you want to, becoming a member of Byte Club is the best way to do it. Either by joining through YouTube memberships or supporting on Patreon. It really, really does help to do that. Otherwise, if you can't, like I said, zero shade, the best way to do it is hitting the like button, engaging in the chat and in the comments, of course, as well. But the like button is like literally the easiest way. So if you guys do not mind and you are enjoying it, I would love it if you would hit the like button. All right.
But certainly that would have been available to you had you looked at it, correct?
Well, but the artifact you show me is from the power log. It has nothing to do with the GPS, so it's not correct.
You could have looked at that exhibit, right?
Yes,
the information in that exhibit to see the 3 different clocks, sir?
Yes, but I can explain why this is incorrect.
All right, maybe Mr. Lally will ask you.
Sounds good.
But you would agree with me if there's a 3-minute difference between the clocks and you don't know which clock was used to put John O'Keefe's phone on Oakdale Road at 2:22 a.m., that could explain. Let me just have a moment. It's not 2:22.
No, I know what you meant.
Mr. Jackson, thank you. I'm sure everybody else did. With regard to the 3-minute discrepancy between the clocks, and you've said you don't know which clock Waze was using to put John O'Keefe's phone on Oakdale Road at 12:22 a.m., that could explain the discrepancy between the Apple Health data and the Waze data, could it not?
No.
But as you sit here today, you don't know whether Waze.
No, that wouldn't explain the discrepancy. I'm sorry. Yes, it could. But the fact that he's like, no, it couldn't. I didn't bother to look at it, but no, it couldn't. 100% dead set on Waze being right. That is the correct timestamp.
Was relying on the baseband, display, or monotonic clock, correct?
Again, that's not, can't be used for that.
Now, you're aware that Jennifer McCabe signed a.
He's trying very hard to remain firm, but it's readily apparent that this is a ridiculous stance to be taking and to be remaining on. He's really going to die on this hill, it seems. But that's fine. Let him die on the hill. The jury's going to make their conclusions anyway, regardless. Just because, thanks so much for the super chat. This is an understandable error, but this should have been double and triple checked by himself and peers and a supervisor before using it for trial. 100% agree. 100%. Because if you are arguing that the timestamp is the reason why you absolutely can rule out all of this Apple Health data about John O'Keefe going up and down the stairs, you got to make sure that that's correct. That's a very important part for the prosecution's case to try to explain away this Apple Health data as a potential source for reasonable doubt for the defense. So for the defense, let me remind you, it doesn't actually matter if, or not that it doesn't matter, but they don't have to prove definitively that John O'Keefe did in fact take those steps at 34 Fairview Road at, around 12:22 a.m. or 12:23, what have you. And they don't have to definitively prove it, right? Because they are not the ones with the burden of proof. All they need to show is that there is reasonable doubt as to what in fact happened here. They have to show that, yeah, that could be a plausible explanation for what happened, what John O'Keefe was doing at that particular time. It's up to the prosecution to definitively show, no, that's not possible because he was over there on Oakdale Street because of the Waze timestamp and whatnot. If they are going to use that as that very important data point to rule out that potential source for reasonable doubt, they have to make sure that that is correct. And so here, David Yannetti is just like, it's like that was a, like that explanation for why that reasonable doubt doesn't make sense. The stairs thing doesn't make sense. That's like a balloon that's on a string here. And David Yannetti just untied that string and it's just floating away at this point.
A consent form on February 2nd of 2022 for her cell phone to be imaged?
Yes.
And a full forensic extraction was performed on that phone sometime shortly after February 2nd of 2022?
I don't remember the exact date. I didn't download her phone.
But in any case, you generated a Celebrite full file system extraction report on May 31st of 2022, correct?
Yes.
And you were aware that Celebrite report was the one that was turned over to the defense in this case, correct?
That is correct.
But you'd agree with me that extraction report didn't contain anything close to the full file system, despite the name on it, correct?
It did.
Well, that report was filtered to return only Jen McCabe's communications with Karen Reed, Kerry Roberts, John O'Keefe, and Kaylee Furbish, correct?
That is not correct.
Did Michael Proctor instruct you to pull only those communications?
Objection.
You didn't seek to obtain any of Jennifer McCabe's communications with her sister, Nicole Albert, did you?
I didn't go through, like I said, didn't go through Jen McCabe's info.
And you didn't seek to obtain any of her communications with her daughter, Allie Albert, did you? I'm sorry, Allie McCabe.
Objection. May we approach?
Sure.
Okay. 1 second. And then we'll fast forward. Also, Wingy158, thanks so much for the super chat. Trust me, bro, I'm a cop. You know I'm right. Oh man, it would be nice if we could, But as this is an adversarial process, we should never rely on someone's just trust me, bro.
You would agree with me that the full forensic image of Jennifer McCabe's phone was not shared with the defense until it was requested by us in October of 2022, sir?
That is not true.
When you wrote your report on April 24th of 2023, in response to an affidavit provided by Rick Green, the defense forensic computer expert, it was in that report that you finally disclosed for the first time the existence of 3 Google searches by Jennifer McCabe, correct?
Objection.
All right, so ask that differently.
Prior to April 24th of 2023, you had not reported in any formal manner with anything that was shared with the defense about the existence of 3 Google searches by Jennifer McCabe, correct?
I never looked at Jennifer McCabe's phone.
And so was there anybody else from your unit or anybody else that you worked on that provided that material to us?
Not that I know of.
All right. Page 2, if I may just a moment. Your Honor, we don't have a printout, but I have it on a.
So don't
approach with that?
approach the witness with that? Okay, show it to Mr. Lally first.
So I'm gonna see if I can place this before you without destroying the
I got it.
computer.
Yep.
Sorry, sir. You take a moment to familiarize yourself with that. Do you understand, or can you tell the jury what that is?
Yep. This is you could put in a PDF. This isn't one I gave to you. This is a PDF version of the UFED reader report that I gave. So I gave the portable Cellbrite version to you. This is a copy of it, and I will not testify that anything in this is correct, because this could have been filtered.
But your name is on there, is it not, sir?
Yes, it is.
All right, and what's the date?
May 31st, 2022.
Thank you.
Yeah.
I mean, that's fair for him to say, I can't verify the accuracy of any of this because it's not in the same format as what I turned over to you. That's entirely fair.
You'd agree with me with regard to that April 24th of 2023 report. On page 2, you state, quote, in my initial Cellbrite UFED reader report, and then you put version 7.53.0.29, that was created on May 4th of 2022, the search history for Jennifer McCabe's phone had 2 Google searches in Safari, correct?
Yes.
And you list out how long TI die in CIKD at 6:23:51 and Hoslong to die in cold at 6:24:37, correct?
That is correct.
And by the way, with regard to the timing of those 2 particular searches, you are aware, are you not, that Jennifer McCabe placed a call to Brian Albert at 6:23 and 0.
Hang on. Earbud is down. Should be connected. There we go.
0 seconds?
I don't have it in front of me. I don't.
Yes.
Thanks.
All right, sir, I placed before you a document. Could you familiarize yourself with that and then tell the jury if you recognize what it depicts?
Have a call log that says 20888 with no name at 6:23. That's incomplete because there should be 3 other records accounting for this call.
Okay, but that record itself reflects a call from Jennifer McCabe's phone at 6:23 and 0 seconds?
I don't know. There's no number on here, so I can't tell. It just says it's a call log with one call that's not answered at 6:23 in the morning with, doesn't say who it's from or who it's going to.
Okay.
It also is incomplete because there should be 2 other records with this. This is from the call history stored data wall, marked as deleted.
It's marked as deleted. Does it give a duration?
It just says duration 0 seconds.
Okay, and does it reflect that it was unanswered?
It does.
Okay. May I have that mark for identification, please?
Okay.
Okay. Interesting. So I think, so the point that Yannetti might be trying to point at is there was a, supposedly a 6:23 a.m. Google search that he wants to try to definitively disprove that would have happened at 6:23 a.m. I think maybe by saying that she instead called someone at 6:23 a.m. and then deleted that call. So there's something there that they're trying to say. They're also going to be referring to it with their experts in the defense case in chief. So, it's the same thing with the overall the PDF on the laptop and whatnot. And also there was also this point here, which I think now is a good time to bring it up. Phantom Split, electrical engineer here. Some of the clocks are internal only and apps will not communicate with them. I think the argument will be shut down and redirect unless there's a way to show that the Waze app actually did communicate with John O'Keefe's phone, perhaps, which that could also be another thing that during the defense case in chief, their digital forensic expert or experts will be able to testify to. So that would also be an interesting point, but that's a very, very valid point to point out. I'm glad we have people from different areas of expertise in the chat, because that always really helps to inform a lot of the stuff that's going on here.
Thank you.
Did you investigate whether a call was placed from Jennifer McCabe to Brian Albert at 6:23 in the morning and 0 seconds?
I didn't look at any specific calls that morning. I created a Cellbrite report. That's about it.
Did you ask either Ian Whiffen or Jessica Hyde to look into that issue?
Objection.
Sustained.
You would agree with me that that call and the record of that deletion of that call is nowhere in your April 24th report, correct?
I believe it's in my May 9th report.
All right, but I asked you about your April 24th report, sir?
I didn't address anything regarding phone calls in my April 24th report.
All right, now going back to when you began your examination around May 4th of 2022, you were looking for information on, did you look on Jennifer McCabe's phone back in May 4th of 2022?
Did I physically open the phone or did it?
Did you review the data at all?
I'm confused, on the cell phone itself or from the report?
Either way.
No, her phone was returned to her and then we had the extraction. I did not utilize the extraction at all.
You never included the 2 searches that we discussed, the, how long TI die in CIKD and how long to die in cold, in the full file system extraction that was turned over to the defense, did you?
They were included.
Well, page 6 of your April 24th, 2023 report goes on to state that when you switch to a new version of Celebrite, and
sorry, that
dropped out.
Yeah, it was the phone call, the power log.
Page 6 of your April 24th, 2023 report says that when you switch to a new version of Celebrite Physical Analyzer, which was version 7.61.0.12, you found an artifact from the browser state DB wall file for a Google search of Hoslong to die in cold at 2:27 and 40 seconds, correct?
Yes.
May I approach?
Yes.
Just because, thanks for the super chat. In a reboot of the Golden Girls, Roses from Canton.
Trooper, I'm placing before you what has been marked as Exhibit 99. Do you recognize that?
Yes.
And what is that?
It's the searches that were done at 6:23 regarding the misspelled how long to die in the cold.
Okay, and it's actually Hoslong to Dying,
Yes.
right? HOS?
Yep, that was,
And that was marked by Celebrite as deleted, was it not?
yes.
All right. And your April 24th, 2023 report goes on to mention 2 deleted calls to Jen McCabe's sister, Nicole, who was saved as Coco in her phone, correct?
I'd have to see it, but I believe so.
Okay. May I approach?
Yes.
Thank you.
Showing you what's been marked Y for identification. If you'd familiarize yourself with that and look up at me when you're done.
Okay.
Does that show the 2 deleted calls to Jen McCabe's sister, Nicole, who was saved as Coco in her phone?
I don't know who it's coming from, but it does say it's going to Coco, and then, again, coming from wall files, correct.
All right. And your report doesn't mention it, but what was the duration of those 2 calls according to that log?
On this sheet here, it says 9 seconds for the first one and then 7 seconds for the other.
All right. And those calls, both of them, which actually had durations, were marked answered by Celebrite, correct?
Yes.
May I offer that, Your Honor?
Do you need both?
Objection?
I believe it's already in, but
I'm sorry?
I believe it's already,
Why for identification?
no, I understand. I believe Ms. McCabe's phone calls and all of that is already marked as an exhibit months ago.
Your Honor, I don't think there's any harm in marking this, and I want to display it.
All right, I'll let you display it if it's already in evidence. I just don't want duplicates.
I understand.
So what I'll do is I'll let you display it, and then, Mr. Lally, at some point you find where this is, and we will mark this like A to whatever
Okay,
the
that makes a lot of
whatever
sense.
the number is.
Thank you. All right. Mr. Bates, if you could display what was marked Y for identification. And Trooper, with regard to what is displayed on the screen now, is that consistent with what I had just handed to you?
Yes, it is.
All right. And with regard to the first entry there, you had stated that it doesn't say you said it doesn't say who was making the call. Was that your testimony?
Yes, just says right here,
Yep.
2. I'm guessing that's the last 4 of the number, since the rest is blurred, and then, yeah, that's it.
Okay. And you know that 0204 last 4 digits, that is to somebody who was listed as Coco in the phone, correct?
I don't know any of these phone numbers or people.
But you previously testified these 2 calls were somebody who was named Coco in the phone.
Oh, yeah, from the sheet you gave me that shows it.
Okay. And the time of the first call was 6:07:42, is that right?
That's correct.
And you testified that that's the one that had the duration of 9 seconds?
Yes.
Listed as answered
Correct.
and deleted, correct?
Yes and no, and I can explain if you'd like.
It's listed as deleted, is it not?
There's a reason why.
Is it listed as deleted?
It is, but there's a reason why.
With
Just say
regards to
it
the
says
second
deleted
call,
on there, yeah.
That appears to be to the same number, or at least the same last 4 digits.
Yes.
And in the sheet in front of you, that's also to Coco, correct?
Yes,
And that has a timestamp of 6:08 and 17 seconds, correct?
that is correct.
That also has a duration, and that's of 7 seconds,
Yes.
also listed as answered,
Yes.
and also marked deleted, correct?
Yes, and there's a reason.
And
I am curious because I don't know. They haven't talked about call history DB. People who are very well versed in this kind of stuff in the chat, can anyone confirm it? Is that a wall file, call history DB, or is that one of those more permanent spaces in the phone storage data area? Let me know.
are you aware
Just
that
curious.
Ms. McCabe made other calls that morning, which were in fact marked unanswered by Celebrate?
Again, I'd have to see what you're referring to.
So as you testified to here today, you have no memory as to whether or not she made a number of other calls that were marked deleted, sir?
There are a number of calls that morning. I have not memorized all of them.
And
Well,
again,
and I
Your
was
Honor, if I
thinking-
may approach
See, I didn't all file.
something that's on a computer screen.
Okay. Yeah, thanks on his mic. Yeah, source. Okay. I didn't see that part that it actually did say wall in there. Yep.
I've placed before you
Thanks,
what appears
Major.
to be a PDF document on a computer screen. If you familiarize yourself with it and look up at me when you're done.
Okay.
What does that appear to be, sir?
An incomplete PDF of the call logs from whoever's call log this is.
Okay. And do you see in that PDF that there were a number of calls that were marked unanswered by Celebrate?
Again, I can't testify to any of this because I can't confirm that where this data came from. There's no source file. This is it's incomplete. So I do see what you're talking about in that column, but I don't know what any of this data is from or who made this.
Is your name on it?
At the very top, it would show my name no matter what because I created the UFED and the extraction. I did not create this PDF.
So the answer to my question is your name is on that document, correct?
It is, but I didn't create it.
Right. And with regard to the calls that were marked unanswered, would you agree with me that Celebrate had them with durations of 0 seconds?
Objection.
Can you agree with that? Can you answer that question? If you can, please answer it.
With the data given here, I can't because, like I said, I don't know where they got this from, Your Honor.
So who created that document?
I don't know.
So are you testifying that nobody in law enforcement created that document, or no forensic expert for the Commonwealth created that document?
I created the extraction and made a UFED reader report, which is basically a portable Celebrate version that I use at the office. I gave that to defense. I don't know who created this PDF version of data with specific things. I did not.
Was it Michael Proctor?
No.
Was it Michael Proctor? That's funny. I will say that it's fair if he says, I don't know who created this PDF version of it. I don't know if maybe they have changed anything from it when they were making the PDF, either converting it or afterwards. Like, I can't speak to anything that could have possibly been changed from here. That actually is fair because, we want to ensure that if we are going to be tying people down to particular documents, that we can properly tie them down to those documents, that they know, everybody knows where this comes from. Everybody knows, who made it and whatnot, and that they can speak to the accuracy, veracity of it. So, that's a legitimate point in my opinion. There's a lot of stuff that he's said that he's been squirmy on, that he's been wiggly on, that I haven't really liked. But like on that point, I don't. It doesn't make me mad.
They said I was the only one that created any Celebrate related reports in this case.
Well, I'd like to ask you some questions about my client's cell phone, sir.
Okay.
On Tuesday, when Mr. Lally was questioning you, he had you point out and read some text messages that were on her phone between John O'Keefe and her, correct?
Those messages were taken from John O'Keefe's phone.
Okay. Would you agree with me when he was pointing out those text messages to you, he skipped about 40 pages of messages at one point?
I don't know. I believe their text messages went back all the way to 2020 or something ridiculous in his phone.
He started reading them and he skipped ahead about 40 pages, did he not?
I have no idea.
Michael Proctor seized my client's phone on January 29th of 2022, did he not?
He did.
And you would agree with me that certainly as of 6 days later, your February 4th report, you had not yet been able to access the content of the phone, correct?
That's not true.
At some point, you were able to access the content of the phone, correct?
Yes, on January 31st.
Of 2022?
Yes.
All right. You later became aware that Michael Proctor was searching through my client's phone in August of 22, correct?
The actual device itself? Or the extraction report?
Either one, sir.
I have, I'm sorry, Miss Reed's phone?
Yeah, yeah.
Oh, yeah, we
Did I
didn't,
say John O'Keefe's phone?
yes, that's why I was
I
confused, sorry.
apologize. I'm not trying to confuse
Yeah.
you.
No, you definitely
With
said-
regard to my client's phone, which is where we started.
Yeah,
You're aware that Michael Proctor was searching through her phone in August of 2022.
of the extraction report created, correct.
Were you made aware that on January 1st of 2023, the defense requested a full forensic image of Karen Reed's phone, which was in your possession?
I don't know the date, but a request was made for the phone extraction, yes.
And have you seen a forensic image or celebrate a report of the forensic image from Karen Reed's phone?
The redacted version that I received back from the AG's office, yes.
Okay. And would you please tell the jurors how many phone calls were deleted from Karen Reed's phone from January 29th of 2022?
None.
And if
Also, really quick, Manny Fabani, thank you so much for being a member for 22 months. As an observer, defense seems pretty unprepared. Yeah, this is not the strongest cross-examination. He's kind of getting stuck in the weeds in some parts. He's stumbling a bit. I will agree with that. This is not the smoothest cross-examination by the defense or by Yannetti himself.
you'd please tell the jurors, other than to John O'Keefe, to whom did Ms. Reed place phone calls between 12 a.m. and 4:30 a.m. on January 29th?
Her parents twice. There 2 or 3 times there's calls to her parents, and that's it.
And how many Google searches did she do from 12 a.m. until 5 a.m.?
I don't believe there were any.
And how many Google searches were deleted by Ms. Reed at any point on January 29th of 2022?
I can't speak to that because we got a redacted version of the report, so I don't know what was taken out by the AG's office. I don't know what files they went in to remove, so I only have what I was given.
But leaving that aside, sir, with regard to all of the data that was provided to you, how many Google searches did you see or find that Karen Reed deleted from January 29th of 2022?
A few.
During what time period?
The afternoon, but again, there was artifacts that I found that weren't date and time stamped, and there were some that were with corresponding timestamps, but I can't say for sure when that was done.
Okay. But you saw no deleted calls, correct?
No, not that I know of.
All right. I may have a moment.
Yes.
Sorry.
No further questions. Thank you.
Okay.
Yes.
Okay.
Okay, thank you.
Redirect.
Mr. Guarino, you were asked about your qualifications as far as certifications that you received in prior trainings, correct?
Yes.
What are some of the areas that you received certifications in?
Cell phone report creation, extraction, cell phone repair, the Berlin Motor Vehicle Forensics, advanced database. The class is called CASA, but it's a Cellbrite-made class that goes deeper into the database searching. SQLite programming to write code to do your own searches, things of that nature.
Now, at any point in time, did Trooper Proctor ever tell you that he retrieved Mr. O'Keefe's cell phone directly from 34 Fairview Road?
No, he didn't.
Is it your understanding, or subsequently did you learn that Kerry Roberts actually recovered the phone from under Mr. O'Keefe's body, from the grass under his body at 34 Fairview Road when he was placed onto a scoop stretcher?
I don't know who recovered the phone that morning, but I know.
I'll allow it.
I don't know.
Your answer is you don't know who recovered it?
No, I just know that it was found underneath his body and then taken to Canton PD.
Now, with regard to that, as far as
honestly, like him saying that the phone was found under John O'Keefe's body just like reminds me of Trooper Paul's cross-examination. And when, Jackson was asking him about like the field of debris and like, how is it possible that his phone was found under him if he was launched like 30 or 40 feet from the car, launched either in the air or dragged on the ground, what have you. Like how could that be possible if he had his phone found under him, if the loose objects would be dropped basically first?
the location data post 6:15 a.m. What, if anything, did you observe in reference to that?
There was some intermittent native locations that showed at the Canton PD. It's there for a handful of different points, and then it shows it back at our office when I put it into the digital evidence lab, powered on to plug in.
You received the phone from Trooper Proctor. Was that either in airplane mode or Faraday back?
I don't remember offhand.
But there were no locations or GPS locations that you observed from the phone from that approximately 11-something a.m. until you retrieved it or received it, excuse me, at 7:30 p.m. on the 29th?
There's, like I said, there was only the handful that showed it at Canton PD, and then when it's back at the office that night. And then if it wasn't in airplane mode, there would have been something I would have done. So I don't remember if Proctor did it before he gave it to me or if I did it after.
Now, the other troopers in your unit, in the detective unit with the Norfolk DA's office, are they as well versed on cell phone extractions and cell phone data as you are?
No.
And so again, how many people within your specific unit actually perform data extractions or forensic analysis of cell phone?
Myself, Trooper Connor Keefe, and everyone has been trained in how to use Cellbrite and to do these extractions. They all just sort of dump them on my desk and say, do this phone for me. So.
Now, as far as what you provide to one of the investigating troopers, such as Trooper Proctor, can you explain to the jury sort of that process of how what, if any, differences there are between what you're looking at as far as the device when you're extracting the information and what you provide to the trooper?
So when I plug into Graykey or Cellbrite or whatever tool I'm using to extract the data, it creates that zip file, and then I open it up in Cellbrite or Axiom. The guys are only trained in Cellbrite, so that's what I open the extractions initially in for them. If there's something that we find that they don't understand and that I want to look more into, I'll load into Axiom as well. But that's normally how it would go.
Now, is there any way from the version or the extraction that you provide to the trooper, is there any way for that or any trooper to change or manipulate that data from what is initially contained on the phone?
Well, in essence, you could, but you'd have to go in. So once I create like that UFED reader, which is the portable case, you would have to go into the folders and then delete stuff, which would change all of the data. And then when I would load it up later, it probably wouldn't work right. But that's why we save the encrypted extraction onto the server. So if anything ever messes up, we can go back and reload it, and I can create whatever reports I need with it.
And so from your review of the data in the phones in this case, what, if anything, did you observe in regard to any manipulation of data or deletion of data or removal of data from what you observed?
From the encrypted files that we have, none. And then we didn't have passcodes for the phones for John O'Keefe's until the 31st, and then again for Miss Reed's until, like I said, August, once the program was able to open it.
Now, you were asking questions about Mr. Green's affidavit. Following your review of Mr. Green's affidavit, what, if any, steps did you take in relation to what was indicated in there?
So as I said, I didn't really go through the phones much when we first got them. I don't know everything about the cases the investigators do. So I got his report and I went through it and basically just went step by step. So he says, this happened. I went to confirm it. If it didn't, then I need to find out why he was either incorrect or slightly off and either just completely wrong or just misinterpreted the data. And that was it.
And in addition to yourself going through some of the data, who, if anyone, did you contact to assist or to also, in addition, go through the data specifically as it related to the searches for Mr. Case?
So initially, when I first found it, I spoke with Chris Vance of Magna Forensics. He's their head technical guy for Axiom. He's like the forensic specialist. So he was at the cybercrime conference. I brought him.
I'm going to allow this.
I brought the extraction there and I said, hey, this is what I'm seeing. This is what it parsed out. Why are we seeing it marked this way? And he goes, well, first off, you have to look exactly where it's coming from. The browser state
Objection.
So I'll strike that last part, what he told you.
Okay.
Yeah, it's your.
Just reviewing the data, we saw that it came from the browser state DB file and .wall file, I should say, at the end. So it set off a lot of red flags. And then from there, we contacted Cellbrite and ultimately Jessica Hyde.
And ultimately, Mr. Whiffen as well, is that correct?
Yes, he came in after Cellbrite. I reached out to them and they escalated it up, and he reached out to us to help us.
Now, with respect to the health data that you were asked about, again, if you could explain to the jury when something in there in the health data says steps, what exactly does steps mean?
As I said before, the phone is seeing movement. Doesn't necessarily mean you're taking steps. If you have the iWatch paired to it, you're going to get a greater level of accuracy, and I would be more apt to believe that steps are being taken because it's going to also bring your heart rate. So if you're taking a large amount of steps, it's going to correspond.
Now, you were asked a lot of questions on cross-examination about just the health data and just the health data. Why is it that you look beyond just the health?
Well, we have the GPS points as well as the health data. We're trying to look at everything together as a whole. You take one artifact and say, well, this means this, but you could have 5 others that disclaim it. So that's why we look at all of this stuff.
Now, from that same information as far as the GPS data, that indicated that Mr. O'Keefe's phone arrived at 34 Fairview Road at 12:25 a.m., correct?
Yes. Now, as far as the clocks or the 3 different clocks that was presented to you that's now been marked for identification, you indicated that those were not accurate. Is that correct? Well, the file that it's coming from is not accurate. So it came from a power log file. That's the database it pulled from. So that it's telling you the power of the phone. So when I looked at that, that also shows the battery level. And that's how I was able to show that, or see, I should say, that John O'Keefe's phone never turned off. It dropped down to about 17% battery level. From being under his body, it was actually saved it from dying overnight. Then it also shows the timestamps of when it gets plugged in and as it goes up. That has 3 different timestamps. That's what that is from. That is not when Waze is started. That is not when the address is put in. That is strictly for the power log. There's nothing to do with anything else. And so, just sort of to that point, what, if any, connection to those timestamps in the the document marked for identification Mr. Unetti showed you, what, if any, relationship does that have to the timestamps contained within either the Waze or GPS native locations or anything else that you were testifying about before? It's literally showing that Waze has been opened and that it's pulling power from the phone, and that is it. That is nothing else. Now, with regard to, you were asking questions about Ms. McCabe signing a consent for extraction on February 2nd, 2022, correct? Yes. And Ms. Carrie Roberts, she did the same on the same date. Is that also correct? Yes, I believe so. Now, the entirety of those extractions from both Ms. McCabe's phone and Ms. Roberts' phones, those were both provided well in advance of the dates the council was indicating, correct? That is correct. Now, in regard to the Legalbytes extraction, in regard to Mr. Green's affidavit, Legalbytes has periodically updates the versions of their software, correct? That is correct. And if you could speak a bit about sort of the update in those versions and how that pertains to this case and specifically Ms. McCabe's searches. So the initial report that I created with version 7.53 did not have that item to be able to be taken out. I was told by Cellbrite that 7.55 was the version that was enabled. Mr. Green used version 7.61, so that's why it presented itself then. Can I just stop you there for 1 second? The version that Mr. Green used, was that available at the time that you did the initial extraction? No, it wasn't available for like a year later. It was like 10 upgrades later. Sorry, sir, continue. So again, he did the extraction, he looked at it, finds this artifact that's parsed out, and then I had to go back in and scramble to say, well, why didn't I see it the first time when that report, why didn't it pull? So I reloaded the 7.53 version. It's not there. And then when I loaded into 7.61, it is. So there's just an issue with the software at the time. So, sir, with regard to those Google searches, what, if any, opinion did you have as to when those Google searches were conducted? When Ms. McCabe told us that it happened at 6:23 and 6:24. And then there was a third one later at 10:35 that, again, if she reopened that browser window, it's going to reload the search. And then that was it. Those are the 3 times that I saw in the phone extraction that were real searches. And why is it that it's your opinion that they occurred at 6:23 and 6:24 in the morning and not 2:27? Well, it's physically impossible to search 2 things at once. Her phone, she's searching the daughter's basketball at 2:27, and then she's searching It's Raining Men and a few other things on her phone, listening to music. And I think then she goes to bed a few hours later. So I was told as the defendant asked her to search for those terms, that's when we believed that they were done. Now, as far as all files are write-ahead log,
having things listed as deleted. If you could just speak a little bit more about that as far as why would something be listed as deleted in the wall file and what does that mean?
Again, the user has no input on how a wall file is deleted. It's an automated thing that the database does to clean up. It auto deletes after either programs are closed, it reaches a max data allotments for that page. That is it.
And that would include any sort of call log history that was contained in the write-ahead log of the wall file as well?
That's correct.
And so what, if any, opinion do you have as to those phone calls that you were showing in relation to the contact listed in Ms. McCabe's phone as Coco, as far as whether or not they were user deleted?
Well, again, what the defense showed me was limited thing. I know should be 2 other locations that phone call was listed from looking at it myself. So I don't know why they gave me just the 2 deleted things, but there should be other spots in the database where that phone call was there. So I don't believe that it was user initiated. It was phone initiated.
And that's in reference to the write-ahead log, sort of first in, first out as far as data that comes in. Is that correct?
That's correct.
Now, again, as far as your unit was concerned, you were the only one who created any cell bite reports in relation to any of the phones, in this case, with the exception of the defendant's phone that was created by the Attorney General's office following their extraction of privileged material, correct?
Objection.
So objection is sustained as to the form. This seems a good place to stop. So jurors, we'll take the luncheon break. There is a chance that we may be able to go a full day tomorrow. So just think about that at lunch. If there's any emergency that would prevent you from being able to go a full day.
Again, things changing. Okay. All right. Cool. Alrighty. Is there anything else before they officially go to lunch? No. Okay. So that started, what time exactly? That was how many minutes ago? About 30 minutes ago. And, oh no, did she say when they were coming back for lunch? Sorry, let me go back.
A full day. Sustained as to the form. This seems a good place to stop. So jurors, we'll take the luncheon break. There is a chance that we may be able to go a full day tomorrow. So just think about that at lunch. If there's any emergency that would prevent you from being able to go a full day.
My guess is this is a full hour. I wish you would have said when they're coming back. Okay, well we can hit live. So then we're back, or we're on. You know, this is 30 minutes into the lunch break. So we don't know if it's going to be starting like now or maybe in another 15 or 30 minutes. I'm going to continue monitoring. I'll go live just a few minutes after they go live because this is you know, I'm breaking this up into morning streams and afternoon streams. So what we'll do is we will answer the questions that are in the chat currently, and then we will we'll end the stream, and then this will redirect directly into the afternoon stream, and then we'll get started on that as soon as they start. Lately, it's been starting like she's been giving like 30-minute lunches. And also the photo of Indy from X or from Twitter. Yeah, let me do that right now before I forget. And we're also going to need to close that poll. Let me see here. Here it is. Okay, let me share my screen here. I just love it. So I said Indy's whereabouts in late January 2022 were questioned in the chat today. So to exonerate her, here's Exhibit 146, a photo from early February 2021 when we first adopted her and have kept her ever since. Look at those adorable puppy eyes. Case dismissed. #Karen Reed. I mean, look at that. She was so tiny. I mean, there's nothing next to her to show the scale, but she was so tiny in comparison to like her size right now. It was so cute. I mean, just look at that. Just look at that. She's like staring directly into your soul. All right, let's turn it back to the Court TV page. Okay. All right. Let's get some questions and then we will end the stream as well. Okay. Starting here from Jonathan Willig. Question, answer regarding the Ring camera. Also, let's do this. Regarding the Ring camera, Brian Albert had received a Nest security system for Christmas and hadn't set it up yet. Across the street was Deputy Chief of Canton PD, and his Ring didn't record. Also interesting stuff. Also interesting stuff. I mean, it could be that Brian Albert had just not yet set it up. It's about a month after Christmas, but hey, that happens. Yeah, so that's entirely possible also. And Krikorovich 997 or 1997, thank you so much for the super chat. Have you seen Auntie Bev's KR trial parody on YouTube? I have. It's very funny. Definitely recommend people going and checking it out for sure. And let me just make sure I haven't missed any recent questions. Okay, we're good on that. Okay, Eximo, Alita, can the jury discuss the case amongst themselves during recess and days when there is no court? No, they are supposed to be tight-lipped on all the thoughts that are going on in their brain as to the case and the details in the case. So, yeah, not allowed to talk about it even with each other. Daniel Evans, question: what about all these witnesses having attorneys? Right? We are not supposed to call that into question. And we shouldn't, right? To me, it doesn't matter that Brian Albert and Brian Higgins and all these other people have their own attorneys. It makes sense. I applaud the fact that they have attorneys. That doesn't infer guilt. That infers somebody who is sensible and is looking for someone to help make sure that their rights are not being steamrolled by the government or by anyone else. Hassar 1683. Question, did we not establish that every single soul in Canton was intoxicated on that night? Seems like we have, right? Mew Mew, question, how do you multitask so well between watching the trial and commenting on it, playing memes, checking the questions and comments and tweeting at the same time? It's super impressive. Thank you. I think the answer to that is ADHD. That's the best answer that I can really give on that. So yeah, my brain just naturally goes in all these different directions. Paula Shamek, Legalbytes, do you remember when Jen's texts to JOK were? I don't remember. The specific timestamps. I'm sure someone probably has them documented. Like I know Brandy Churchwell at the 13th Juror podcast. She likes to make timelines of a lot of different things and all kinds of like graphics and diagrams. So I wouldn't be surprised if she had something that she put together on that. That would be really interesting to see the side by side regardless. And I would imagine that the defense has something that they're going to be showing with like very strong accuracy to show these timestamps and things and to really give a good timeline on what they say this stuff shows so that the jury can see it very, very clearly. Sue B, question, was that time Jen McCabe testified she saw Karen? I think it could be. Elena, question, did he walk up and down the hill to show that the phone would record them as stairs? I don't think so. At least he did not testify as to that. So there's nothing to suggest that he actually confirmed that by doing that himself. Noslin Santana, question, when the attorney says, are you aware that, and states a claim, how do we know if it's true? Are they experts in the topic? So that could be potentially objected to or objectionable. If, by saying like, are you aware that, this is a fact that exists? If it's something that like, are you aware that so-and-so testified to X? Are you aware that, that this report, if that's been presented to the jury, then that is facts and evidence. So then it might be okay to do that. But if you just say like, well, are you aware that on this date, such and such happened? That's something that is maybe improper, should be improper, really. Also, Peter Beveridge, thanks so much for the $5 super sticker. Very kind of you. Thank you. All right, just ask this one. Dayan Luich, Legalbytes, could the defense use your and or others' streams and commentaries for themselves to maybe find if they missed something useful, maybe for closing? How likely is it they are looking at us? I would say that there is a 99.9% chance that they are looking at the various streams and content that is coming out that is covering this case. That's actually how I became friends with Natalie Wisco. Was she's one of the defense attorneys for Kyle Rittenhouse. Afterwards, she reached out to me after the trial ended. She reached out to me to say, hey, we were watching the streams that you were on, and you said something at one point that you said that you really, really, really hoped that this particular phrase ended up in closing. She either said I wrote the closing, or she said I helped write the closing, and she said I made sure that ended up in the closing argument. So that was one of the really cool things that I never would have anticipated could have happened. But ever since then, that was the first trial stream that I was on and that I participated in. And so ever since then, that was like a pretty quick realization of this is possible for these teams to be watching what people are saying and to incorporate different things, because someone might have an idea on a live stream or in some sort of a video that maybe you didn't think of because you've been so in the weeds in preparing for this case that something just didn't really occur to you, but someone else says it and you're like, oh, okay, yeah, let's do that. That is 100% possible. So so it is pretty cool to think when that kind of thing does happen. So, and either way, right? Prosecution can be watching this stuff. The defense can be watching this stuff. And I honestly think that the more that there are these kinds of high profile trials and whatnot, I honestly think that it is best practices for the parties on either side to have, or for the attorneys, the legal teams on either side, to have someone, if it's probably not them, the people that are actually in the courtroom, maybe don't have them watching the streams and whatnot, because you don't really have that much time, but someone back at the office watching to monitor this stuff and to give, to give notes on feedback, because there can be value in it. There can also be garbage that's set out there, but there also is value in the idea that people are reacting to this stuff sometimes in the same way that a lay person who is sitting on the jury might be reacting to it. So there can absolutely be valuable feedback, and I think that it's worthwhile to have someone to have their finger on the pulse. Debbie Faison Cook, but saying he doesn't trust that the PDF is right, isn't that like Sergeant Lank not trusting the defense about John's height? Well, no, because what Sergeant Lank said is, well, if it was Lally that said that, I would trust it. That was a dumb remark, in my opinion, because as a witness, you don't want to look biased. You don't want to look biased to the jury, because otherwise they're going to maybe discount or shift the weight as to what it is that you're talking about. But here, what he was saying, what Trooper Guarino was saying was, I can't verify the accuracy of this thing because I don't actually know where this particular version of it comes from. And I don't know if there's been any changes made to it. All right. Shannon, question: if different source of some data should go in as different evidence? Yeah, I mean, if there's any distinctions between different different versions of data or different sources of data, yeah, that would be those would be different, I would say, different exhibits, different pieces of evidence. Yeah. Matt, Legalbytes, as a juror, if an expert witness is trying to give a reason for something the defense is drawing an incomplete or inaccurate conclusion, that would flag my attention. No? No, I mean, well, I'm not sure I fully understand exactly what you're asking, but I think that if you're saying that, if the witness is saying, defense on cross-examination, you're not exactly being fair in the way that you're putting this, that's entirely valid, right? Because there are different ways for a witness to push back on a cross-examining attorney. One of them is by just being stubborn without purpose, just because they're like, I just don't want to give you any information that I know you want, which isn't necessarily a good thing, because you can just look like you're being stubborn for the sake of being stubborn. However, if you have a good reason behind it and you say like for example, Guarino saying about the PDF file, like, I don't know who made this. That to me is a valid kind of pushback to say, like, there's a limitation as to what kind of testimony I'm willing to give on this because of the fact that I don't know who sourced it. So there are good reasons for some kinds of pushback, and I totally agree. Just so you guys are aware, the fan has just come back on, so they might be coming back fairly soon. We got to get these questions done, and then I'm going to, regardless, give myself a little bit of a 10-minute break. So let me get through these questions as quickly as possible. And then we'll get back as soon as possible. Okay, LK Rydan, it feels like what Yannetti is doing is laying breadcrumbs for the future experts, but we can't see how yet. I have a feeling that that's what he was doing too. There were only like one or two real punches that he laid into this particular witness. But he was hinting at some other things that I think that he may be thinking are better to be brought up on direct with another expert. So that is entirely possible. So that may be why parts of the cross-examination felt a little bit messy here. We'll see. Matt, Legalbytes, speeding up the playback makes it very difficult to listen to. I don't want to make a decision until everything is presented, and this feels super biased. I apologize if that makes it harder. I know that for me and for quite a few other people, it actually makes it a little bit easier because of the way that Lally asks his questions. They tend to be long, winding questions, and it takes a while to get them out. And so sometimes increasing the length of those with the pauses and his slow talking, by the time he gets to the end of the question, I've already forgotten what he said in the beginning and in the middle. So that's my own personal preference. That's not for bias. I'm not trying to be biased in anything here. So I hope that you can understand that. I'm sorry if that's making it a little bit harder for you. That's the only reason why I do it. Hazo1, help support Alita on her journey to 250,000 subscribers. Subscribe and ring the bell so you never miss a stream or video. Don't forget to also like the stream. Thanks for being here. Yes, thank you so much for the reminder. We are on the road to 250,000 subs. Let's see, where are we at? Yeah, we are at 246,000. We are hoping to get to 250 by the end of this trial. Can we do it? We are actually inching towards, I checked, we are actually inching towards 247,000. So if you really are enjoying and you want to see more stuff like this with more trials and more, other one-off subjects, we're going to be putting out a pre-recorded video on a case that is, or a topic that is not related to Karen Read at all, today, tomorrow, at some point, as soon as it's officially ready. By the way, Bite Club members will have early access to that. So if you are a member of Bite Club, you'll get it before anybody else does. So things like that, we love putting that kind of stuff out. All of that takes resources. Bite Club is a great way to support the channel with that. But we've got a lot of different topics that we cover. So if you want to be part of that, at the very least, hey, subscribe. It's a fun place to be, to talk about all these different topics. And of course, liking the video does help, regardless of whether you want to be a member or you want to subscribe. Liking the video really, really does help. Okay. Chelsea, Legalbytes, maybe I missed something. During direct, Guarino said Karen initially passed Fairview and made a 3-point turn before dropping Jo off. So now, did she make two 2-point turns? I think that the 3-point turn that he was referring to was actually at that upper intersection of Cedar Crest. I keep getting confused if it's Cedar Crest and Chapman, or Chapman and Cedar Crest. Yeah, I don't know, but I was under the impression he was saying just one 3-point turn, but I may have missed that. Doctor Who 8675309, Legalbytes, Indy was staring awfully deep. Isn't she? She isn't a redhead, is she? Will she steal my soul? She's got a little bit of red in her fur. She just might steal your soul. Be careful. Cont'd 1979, Legalbytes. Okay, just a confirmation. My security system only records my house. Interesting. Okay. Janet G, Legalbytes, I don't know if you saw my comment. I love your spiciness that comes out more due to being pregnant. LOL, can't wait to see how much more comes out during growing baby bites. Oh, I know. I might end up becoming a bit spicier as a mom after this. Who knows? LK Ryden, Legalbytes, I'm fairly sure the judge is keeping track of the socials too based on her behavior. Yes, she was breathing into the mic quite a bit in the beginning. So someone watching the streams and whatnot may have said something to her about that as well. That wouldn't surprise me. I wouldn't be surprised if she herself was trying not to pay attention to any of that, because if I were a judge, I wouldn't be watching it myself, but I would want someone close to me. Like I would have, or Mr. Bites would probably be watching stuff like on my behalf and telling me like, you need to stop doing this. Because he gives me good critique on my content anyway. So I know that he would do that for me as a judge, if I were a judge. Also, joshing you, Legalbytes, where's the vomit? It has been mentioned at least 3 times and no one on the defense is asking about it. I don't know the significance of that. I know that it's been mentioned a few times with some of the prosecution's witnesses that they've mentioned that there was vomit on his clothes, like Buchanan mentioned it, I know, and I think a paramedic mentioned it. That could be a number of things. Could be alcohol. It could be a head injury. It could be a head injury as a result of hitting a taillight, or a head injury as a result of being in a fight. So, I don't know. To me, there being or not being vomit on him doesn't seem to be a big sticking point. Okay, that's all the questions that I have here. And oh boy, yeah, Eminem mentioned it too. He did. Mom spaghetti. So okay, let's end the stream. This will redirect directly into the afternoon stream. The fan is going. As soon as it starts, well, I'm gonna take a little bit of a break real quick to get up, walk around, have some food, make sure baby bites is everything's good. Of course, hydrate, all the good things. And before I do that, poll. I know I've got to end the poll. Okay. All right. Going into day 28, how do you lean regarding KR's murder charge? 86% said not guilty. 9% said need more information. 3% said guilty. And this is 2,500 votes. So a smaller percentage now say guilty. I don't know if that's because the people who were saying guilty before are elsewhere. We've got more people in the chat that are saying not guilty. Or need more information, but that's interesting. That's very interesting to me. But 2,500 people voted. That's awesome. Alrighty. Okay. Thank you to everybody for joining. Thanks to everyone who bought memberships for themselves, for others, people who bought super chats as well. Folks that are just watching with us, whether you are in the chat or in the comments, or you are just watching and lurking, I appreciate every single one of you. And always, of course, last but not least, thank you to the mods for helping to make sure that the chat is a wonderful place for people to join and engage and give their different perspectives and do so in a way that is respectful and helps everyone get to the truth with a capital T. All right. Okay. That for me about does it. I'll see you guys in just a little bit in the afternoon stream where we get more Trooper Guarino. Do we get to finally hear from a medical examiner today? I would love that. I would absolutely love that. I hope so. Fingers crossed, right? Okay, folks, see you soon.